Good morning. Good morning. Good morning, amazing law nerds. It's so good to see you. Replay crew, you guys always get to see this. Law nerds, it's so good. But today, I put up a poll. I know the business sentencing is today. It had gotten put over. I thought they were going to put it over again. They didn't. But when I put up the poll, you guys voted that you needed something a little bit lighter today. So it was within 1%. So here's what we are going to do. We are going to do the sidebars today. A lot of you were already mentally prepared to do sidebars. I'm not going to switch that up on you for all of you that are like, we are so ready. But on Thursday, I will give you time to process that we will do the business sentencing. It is going to involve victim impact testimony and other testimony. So we will do the business sentencing on Thursday, and then depending on how long that is, other news and stuff. I have a hard stop on Thursday, so we need to go see all of that. Tasea said Bitboy arrest would be interesting. When did Bitboy get arrested? What? I have no idea, but we're going to have to take a look at that. Because I thought he only had civil cases going on. So we're definitely going to look at that. For those of you asking about the taking care of Maya case, it is a civil case going on right now in Florida. I am not going to cover that. Got arrested on stream last night. Chat, are you sure he didn't get swatted? Was he avoiding court? Oh, we're gonna have to look at that. I will go look at the other coverage of it. I wonder if he had a warrant out from court. I don't know the situation at all. We're going to have to do that because I am fascinated. Yes, legalese is hard, bro. Apparently got arrested. I will figure out the coverage because I have no idea what happened. Today I've had kiddo stuff. It is a very busy week of family stuff. Like I am in mom mode most of this week. So that's wild. So I am not doing the taking care of Maya trial. I am getting ready to leave. I know Lawyer is updating it. I believe Law and Lumber is going to be updating it. And so we're going to do I'm not going to cover that. They are covering that. It's a really, really sad case. If I'm going to cover any of the 8 passenger stuff, there is only so much I can take on at once. And I am working on some crazy stuff for you guys. There is a case that we covered lightly a while ago that has gone off the rails, but there's so much that has happened. It's going to take me a minute to cover. So, Runkle's covering it too. I am not surprised. There is tons of coverage. I am not going to cover it. So that's what's going on. You guys, I don't know if it was contempt of court. I'm going to have to find out. I will find out. All right, let's just we're going to take a look real quick. I guess we're doing our quick bits today. That's going to be our breaking news quick bits. Emily, you normally don't cover breaking news. No, but I'm really interested in this. Sometimes my ADHD will go, yes, please. And sometimes it's like, no, thanks. Today's a yes, please. We'll go take a look. But the need wearer, love your boundaries. Thank you. The taking care of Maya case is I choose what cases I cover. If I wanted to just do live trial coverage, we could cover things every single day, all day, every week. Like it would never end. We could just hop trial to trial to trial. That's not what I want to do with my content or this channel. 1, I respect myself and my time. And 2, I respect you and your time. I don't want to just drag you into cases that are going to be tremendously difficult if I don't have something to add to that case or a particular interest in that case. So law nerds, the reason I do this is A, to help explain the law, and B, to spend time with you. And I appreciate you so much. You guys have just been incredible. But when we are dealing with things that I find deeply triggering, I don't find that I can be helpful in it. We cover some heavy cases and some sad cases, but there are some cases that I know are a bit too much for me. And the taking care of Maya case is essentially a civil malpractice case of a child who was not getting the medical care that they needed, that resulted in the mother taking her own life. It is a very, very sad case. I don't know if it was a Netflix documentary, an HBO documentary. The case was covered on one of those outlets. It's just really, really a sad case. So that is not a case that I am handling. Look, man, Netflix covered it. So today we are going to have a little bit of a giggle and do sidebars. We're going to do that. It's a no for me. I don't know if I need to explain that more. I think those of you that know much about that case know why it might be a no for me. It's a no for me on that one. Other things. The Law Nerd app is up and running. We're going to talk about that in a minute. What else was I going to share with you guys? We have some new stuff coming in the merch store. You're going to learn about it first in the app and the email crew. We're going to have some discounts for you in the app as well. I can't wait. There's lots of exciting stuff coming. So I just had to say, like, I don't know. The internet can be a weird place. It's a busy week for me. And the thing I'm most excited about, even though we had to push back the stream today, is sitting down and chatting with y'all. What is to come the rest of the week? Well, tomorrow we are covering the Sophie Turner, Joe Jonas divorce and custody battle. This is an international custody battle. The Hague Convention has been summoned to the chat, and it's a very legally complex situation. I think what Sophie Turner has said is winter is coming, and what we're not going to do is deal with this. So we're going to deal with that tomorrow on the podcast. Meow meow. Does your app sell our info? No. Just like the email list, this is a proprietary app to me. This is an app for Baker Media. This is our app. We do not sell the data of our members. If I'm going to advertise something to you, I will advertise it to you directly on the podcast, in a sponsorship, what have you. I am not selling your information. Nope. I'm glad you asked. Nope. If I am going to sell something, I will just tell you what I am selling and say, hey, this is my sponsor. So that's the app. But no, we absolutely take your data very seriously and have made sure that our app does that. So no, I am not. No, y'all choose to be here with me. I am not gathering your information to sell it off to somebody else. I mean, unless you see advertising or sponsors as that, but when sponsors ask me for stuff, just so you guys know what sponsors ask for, when sponsors ask for stuff, they ask for broad general demographics. When it comes to the app, we tell them how many downloads of the app there are, and that is it. When it comes to YouTube, I give them the YouTube analytics, which are what percentage of my audience is in what country, and what's the general breakdown of my audience by age and gender. That is what they ask for. And then they can see on the front end total amount of engagement. They can see how many people are on the live stream. That's the information I share. That's it. So even when people have asked for more information, I'm like, you don't need that. So that's what we share when I do that. And most sponsors, if sponsors are like, hey, we want to know this, and that, I'm like, nah. Nope. I say no a lot more than I say yes. Why? Because you guys are so incredibly generous. I just saw B2 gift another 20 memberships. Between our members and the things that we have going on, the merch store, our memberships on multiple platforms, we have the opportunity to say no more than we say yes. And that is something that I take very seriously. So thank you for asking, because it's something I would forget to tell you, but no, I don't. And a lot of you are in the UK. So we made sure that the app met the standards internationally so that you guys could be a part of the app crew, because the text crew was only North America and we couldn't extend it. And that was really frustrating. So a lot of you are asking where to find the app. I see Octo is coming in like, girl, why haven't you said? LawNerdApp.com will get you there. And I'll just show you what you get when you get there. And then we'll go. And I was going to do this after I rolled the intro. Let me roll the intro real quick. And then we will get you there. If you're in your app store, just search Law Nerd. And iOS, Apple, Android, all the things. iOS is Apple. I know my brain just stopped there for a minute, but I'm going to roll the intro and then I'm going to pull this up real quick so that you guys can go and download it if you're interested in. It is a free app for you. It was not free for me. It's a free app for you, but the app is available. If you go to lawnerdapp.com, you can go to this window and click your particular store. Do it on your mobile device. It'll make it easier. This app is our international solution. Today was the last ride of the text crew, and we'll talk about that in a minute. So let's roll. That's the podcast intro. Let's not do that. The podcast is tomorrow. Wednesday can't get here soon enough. Y'all are like, hey, convention, we need to talk about that. Yeah, we do.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Y'all, I'm very excited about the app. I was finishing up grabbing my research because my screen was still up, but I am very excited about the app. So if you go on your mobile device, lawnerdapp.com, it will take you right here. You can download it. You can download it in your app store. The app is the best way to get notifications. As we do trial coverage and as my schedule is the fall, which is the fall, we will be able to keep you in the loop. Here is my goal for trial coverage, that I will be able to app notify you every single witness that comes on the stand. And I will be able to tell you that every single time somebody comes up on the stand. If I decide to go live on Instagram, we will tell you in the app. When I am running around at, BravoCon, I will tell you where I'm going to be in the app. If we're going to do any meetups, I will be able to let you know. If I'm going live unexpectedly, what have you. So this app is going to allow us to stay in communication faster and more accessibly. The text crew, again, was limited in ways that I was frustrated with. I was frustrated with the company that we worked with to provide the text messaging services. And I am very excited that this is our solution to it, and a solution that is ours. What we are trying to do at Team Baker is make it easier for you. So every time we ask a question, it's how do we simplify this and how do we make sure everyone can participate? And that goes to those of you that are like, Emily, we need new zip ups in the shop. Yes, we do, but we need a size range that is inclusive, and not every provider has provided that. So it's until we can roll it out and make things accessible, we will wait. And so the text crew was a first and limited solution. This is an international and much broader solution that we will be expanding. It has been a labor of love for the team, and they have done an incredible job getting this all rolled out for you. I don't imagine we will see lots of streamers doing an app. It's a lot of work, but I'm real excited about it, and I can let you know what you want to know, which is I don't want to miss anything. The other thing I like about the app for us is that if you are busy when I am in trial, it is so easy to turn off app notifications. It's more controllable for you. So if there is a case, we're going to have the Murdaugh trial coming up next month. If you're like, I am so out on the murdacity of this dude, I know you're in trial this week, I'm just going to turn off app notifications. You can turn them off and on and be in control of your own experience in a way that works for you. If you are home recovering from COVID, which I saw some of you in the chat saying home recovering, if you're home recovering, you can turn all the notifications on and be like, girl, load it up. Where are we going? Where are we riding? What state are we in today? And then we can do that too. So this was our solution to keeping y'all in the loop. And that is my goal, to keep y'all in the loop in a way that you can control a bit more, and a way that I can provide to law nerds no matter where you live. So this is the solution. I'm real excited. I'm real excited about it. But yes, our next trial, we might do some other court coverage, but our next trial is going to be Murdaugh in November. So I don't think that trial is going to get put over. I think that's probably going to go at the end of November. So that's what we'll be doing. Then we'll get into the holiday season together. The fall is going to be a little crazy, you guys. My travel gets a little crazy, and the app is going to keep you up to date. So, let's see. Kamira asked a great question in the chat that hasn't popped up on this side of the chat yet. Can we choose what kind of notifications we get, e.g. IG, YouTube, live meetings? You on the app can't distinguish between types of notification, but it is a great thought. I can ask what we're going to do. Stina G asked, am I a real YouTuber with my own app? No, not yet. No, not yet. My youngest has said no, not yet. I asked. Trust that. I asked. He keeps moving the goalpost. So he's actually getting a new trial. Tori, you make an excellent point. Let me be very clear. Murdaugh is going to trial for the Gloria Satterfield theft from client financial crimes in November. This is completely separate and aside from the murder case. Hopefully that helps. Hopefully that helps. I'm using Murdacity for fuckers from now on. Agreed. Are we able to talk about the Joe Sophie divorce suit tomorrow? We are talking about that on the podcast. We need a new app emoji. We probably do. We probably do. So with all of that, today we are headed to Virginia. A lot of you are interested in what's going on with Shabusiness. I will look at the sentencing and then we can cover it. I saw a question. Crystal asked, am I covering the Leah Remini case? I have not seen anything new and notable happen since my last coverage, but it's on the podcast the last time. The nice thing about the app is you will be able to search by videos on the app. Let's see. Amanda asked, should we use our YouTube account to sign into the app so they are connected? It will not connect them. You need a standalone login for the app. I would use a separate password than you use for anything else, but you can use the same user. If you want to use the same handle, you can. That's up to you. I would use a separate login, but I use a separate password. I use separate passwords for everything, but the app is not connected to YouTube at this point. All right, chat. I got a news article here. It looks like we're doing quick bits because how could we not do quick bits? Because I don't even know what's happening. Why is I swear to God, Fred. Okay, look. Fred loves my desk and he keeps walking on this keyboard. But when he walks on my keyboard, he loves this keyboard for some reason. I think he likes the thunkiness. I like the thunkiness of this keyboard too. But when there are times when he shifts the buttons from Windows to Mac, and then my keyboard won't copy and paste with the short keys, and I'm like struggling to figure out why I can't copy and paste things. And it's inevitably because my cat has walked on my keyboard and changed literally everything. Fred. Oh, I need to get a camera because Rob's going to be like, did anyone witness him do this? Are you falsely accusing my client of fuckery? I need a cat camera in my office. I do. All right. I guess we're doing a quick bits today because the chat is bae and we can't not. So let's go to quick bits. It's been a minute. We've had very busy streams. So let's quick bits it and see. This is breaking news. I don't know how accurate this reporting is. Let's find out. Quick bits. Thank you, Miguelina, for pulling this article. Ben Bitboy Armstrong arrested after live stream rant. Former Bitboy Crypto host. What do you mean former Bitboy Crypto host? Is he not hosting things? Was arrested after a 37 live stream rant outside his ex-business partner's house. What is happening? Oh dear. So is he no longer hosting Bitboy Crypto? Did something change? Chat. It's all on a live stream. Oh boy. He doesn't go by Bitboy anymore. The artist formerly known as Bitboy? Something is happening. I have so many questions. We're going to have to dive into the lawsuits. There's more legal stuff going on there. We're going to have to look. He was ousted? Oh boy. Okay. There are times when I sidebar. No! Damn it. There are times when I look at the podcast and I look at what we've built and I'm like, there are days when if I don't know, Spotify or iHeartRadio was like, hey girl, I know it's hard running an independent podcast. We've got you. There are times when I can see why that is tempting, but we have built Baker Media where it is us and y'all. Like that's it. It's us and y'all. So there's no ousting. It's hey guys, want to talk about this or this today? It's us and y'all. And that feels better to me. So even though there are times when I'm like running an independent podcast is hard, and it takes effort and a team, the shit's out of the horse on all of this now. Like I've been independent for so long that I don't want to deal with any of this. Like the former business partners and stuff is so hard to deal with. It's us. So I love having control and being able to chat about what I want to chat about. I mean, does that and having the app makes it so much easier to just stay connected with y'all. It's stuff like this. Once we get to ex-host of the Bitboy Crypto YouTube channel, I had no idea that he had been ousted. This is the kind of stuff that reminds me why we just build it together. Because even when I talk, and I've talked to a lot of legacy media types of outlets, I don't want to be told, hey, we're covering this. Like a case like Taking Care of Maya. I am sure that case is getting a ton of views now, but I would hate it if somebody who had control of me, first of all, I don't want anyone to be like, I am the boss of you. But if I had a boss that was like, you're covering this case, you're covering this angle of this case, that wouldn't sit well with me. But it sounds like that's what happened to Bitboy. Okay, crypto influencer Ben Armstrong, ex-host of the Bitboy Crypto YouTube channel, was arrested last night by Gwinnett County Police while live streaming outside his former business partner's house, who alleges he has his Lamborghini. This morning, he took to Twitter to confirm the arrest, saying he did 8 whole hours in the slammer. This comes a month after he was booted from HIT Network, which owned the Bitboy Crypto brand, which Armstrong made famous, and less than a week after a failed bid to reclaim the namesake of the company. What the fuck is happening over in the crypto world? What? Armstrong posted on Twitter that he would be going live from a very special location. This location would be the house of a crypto investor and consultant, Carlos Diaz, who Armstrong claims is connected to HIT Network. During the YouTube live stream, Armstrong alleged that Diaz wanted to kill him and that he has links with the mafia. Oh dear. Is there going to be a defamation suit after all of this? And he claimed that he's constantly fearing for his own safety. If you are afraid for your own safety, don't go to the person's house. About 19 minutes into the stream, the local police arrived to question Armstrong. I imagine that the person inside the house was like, excuse me, this person is outside my house. I imagine somebody will immediately do a FOIA request of that 911 call if they haven't already. The police asked if he had a weapon on him. He did not have one on his person, but there was one in the backseat of his car. While being pat down searched, he was asked if anyone else is in his car. He struggles to answer at first, glancing down at his phone that is live streaming to 2,500 people, but eventually admits that the woman he had an affair with is in his car. He claims his wife knows that they are both there. What? What is... are we being punked with this story? Okay. So, okay. At some point, Ben Armstrong got ousted from Bitboy Crypto. Who's covering this? Is it Tuesday covering this? At some point, Bitboy got yeeted from his brand by the people that own his brand. He went to the ex-business partner's house and was live streaming in front of his house, which is a safety issue that I find deeply concerning. I don't like the streaming outside of somebody's house at all. Then he has a weapon in the vehicle and another person in the vehicle when law enforcement arrives. And the person in the vehicle is the person he's having an affair with, but his wife knows, and he's live streaming all of this. Chat. What the fuck is going on? Is it a prank or something? I don't know. I feel you streamed while cheating. I mean, what is... I am so confused. Chat, you're the best for bringing this up. The chat's like, did you hear this? A Tuesday live streamed at CoffeeZilla is covering it on Twitter. This feels like a movie. Yes. A weird one. I thought the stream had frozen. No, I froze. A Tuesday streamed the whole video. Oh, okay. Oh, well, I will. That's what I'm watching after we do the sidebars. Not on stream. I'm going to send you all to a Tuesday's video and I'll go watch it. You can't make this up. No, there's another lawsuit going on. So, okay. For those of you that aren't familiar with Bitboy Crypto, who I don't know, the artist formerly known as Bitboy Crypto, we first started covering him with the crypto lawsuits. And then he was on a cruise and was like, I'm not coming to court, and was tweeting all of it while he was on a cruise. I thought his wife and kid were on the Bitboy Crypto cruise. So between the Bitboy Crypto cruise and the federal lawsuit where he was going after the attorney, the legalese is hard bro tweets, from there, we ended up here. That wasn't that long ago. Okay. "19 minutes into his stream, local police arrived to question Armstrong. The police asked if he had a weapon. How rapidly did like CoffeeZilla and a Tuesday's phones blow up when this was going on? While being pat down searched, asked if anyone else in the car. He struggles to answer at first, glancing down at his phone that is live streaming to 2,500 people, and admits that a woman he had an affair with is in his car. Had? Are we past tense? Why are they in your car? He claims his wife knows that they are both there. Armstrong explains that the woman, who's named Cassie, is involved in the situation with Diaz, and they both came to Diaz's house on the way home from his daughter's tennis match. Were they all together at the tennis match? He then alleges that I'm stuck on the woman he had an affair with is at his child's tennis match, but his wife knows. I have so many questions. Is this a spontaneous choice to go live stream in front of somebody's house? It seems like a bad idea. This seems like a conversation where you just call your therapist and are like, I'm having intrusive thoughts. It seems like this is a good idea. And your therapist is like, no, this isn't a good idea. He then alleges to the police that Diaz has been extorting him, sending him death threats, and stole his Lamborghini. If that's true, don't go to Diaz's house. Go to the police station and make a report. The live stream then goes silent with no image for 17 minutes before it ends. The Lamborghini in question was allegedly bought by HIT Network or HIT Network and given to Bitboy as an employee. Oh, it's his work car. Hold on. I need to message my accountants. I need to talk to my accountants. Excuse me. I need a company car. I didn't realize that buying Lamborghinis was an option. My chat, my phone's going to start blowing up with everybody being like, we need work cars. However, I'm now at the part of life where a Lamborghini doesn't seem comfortable. Like, I'm now mom life. Like, I need like an Escalade. I need something with running boards that I don't have to like squat to get into. A Lamborghini seems loud and confining. I know they're nice cars. It's just not my world. Okay, so the Lamborghini in question was allegedly bought by the network and given to Bitboy as an employee. When the network decided to remove Armstrong, they decided they wanted to sell the Lamborghini to quote unquote recoup funds that Armstrong allegedly quote unquote stole from the company. Oh boy. Is there has to be a lawsuit. If there's not already. Shortly after the live stream ended, listing on the Gwinnett County, Georgia Sheriff's Office shows a white male named Benjamin Charles Armstrong was put in jail on September 25th at 9:11 p.m. That was last night. It appears that he's been charged with loitering / prowling and simple assault by placing another in fear. Look, legal commentary. I can help. Assault and battery are two separate things. You remember this from other content. But an assault is the fear of the thing, where a battery is the touching of the thing. So you can have an assault without a battery. So when a lot of people hear assault, they hear some kind of physical touching. The battery is actually the physical touching, and the assault is the placing in imminent fear of a touching. Look, there was legal commentary to all of this. Diaz has since released home security camera footage confirming that Armstrong was at his house and rang the doorbell. Decrypt has contact with Ben Armstrong and HIT Network, but they have not responded in time for the publication. So you guys have said that CoffeeZilla is covering this. We're doing that next. And then this loop will be closed in my brain and we will move on. Once this loop is closed in my brain, we will move on to the sidebars. I'm sorry for the quick bits sidestep, but I am fascinated. Let's see what Coffee has had to say about this real quick. Let's see. Did Bitboy Crypto just live stream himself showing up at a guy's house who quote unquote stole his Lambo and immediately get arrested? Crypto is so back. Hold on, we need audio. Oh, thank you, CoffeeZilla, for all of this.
Hey, how's it going?
Can you guys hear?
Hey, do me a favor. Yep. Hey, stop. Hey, how's it going? Stop. Oh, stop. I couldn't hear.
You have a weapon on you.
No, I do not.
Okay.
I do not.
So
I have one in my vehicle, but I do not have a weapon.
Does he have his phone in his hand?
Sorry, I reached too fast. I'm sorry. Sorry. Okay.
Put your phone down.
Okay.
Yeah, absolutely. Put your phone down.
Okay. All right. Okay. All right. Okay.
Put the fanny pack down.
Okay.
What's going on?
What's going on? This man inside of this house.
Actually, he's gonna check you real quick.
Absolutely.
Just a weapon.
I'm sorry. I have a. Okay. Okay. Yep. No weapons. No weapons.
Where in the car is your gun?
It's in the back seat.
Back seat?
Yep.
Is anybody else in the car?
Yes. It's in the car.
Who's in the car? Who?
What's that?
Who's in your car?
Who's in my car?
Yeah.
Okay.
Oh, he is. He's looking straight down at the phone. They're like, who's in the car? Who's in the car? Who's in the car? Oh, boy.
Let's,
Who's in your car?
who's in my car?
Who's in your truck, sir?
Cassie is in my car.
He's nervous to answer. Look, He's nervous to answer because he's still live streaming, it seems to me. However, you could hear the police getting very frustrated very quickly, which can become a very dangerous situation very quickly. Oh gosh.
Cassie's in my truck.
All right, Cassie.
Cassie's in my truck. My wife knows that we're here, by the way. She knows we came to do this. But my wife is aware. So we're live on YouTube right now.
He's trying to explain
We got
to,
about
he seems more worried about chat than he is about the police that are asking him questions.
2,500 people watching. So
We have 9,300 people watching, just if we're doing that.
Cassie's a girl I had an affair with. She's involved in the situation with me and this guy here. My wife knows. We were just at my daughter's tennis.
Okay, what's the next tweet? He sacrificed everything to make crypto Twitter funny again. Bad news for Carlos's Lambo. Broke out of jail and I'm on the run. Live stream soon. So we haven't learned anything. Haven't learned anything. Because if you make jokes like that, it's going to show up in court. If you joke, it will show up in court. Oh, God. Is this about Pokemon or something? Yes, it is. It's absolutely about Pokemon, trying to catch them all. Somebody in the chat said Emily's competitive. Reximoto, there's times it comes out. There's times. Police with guns pointed at you greater than chat's thoughts. Yes, but he is not concerned at all. This is going to come up in a hearing. The judge isn't going to be thrilled about this, especially with the behavior formerly in federal court. Oh gosh. Anything else from CoffeeZilla? Let's see. No, that looks like you do not understand how unhinged this really is. I'm reading the tweet from CoffeeZilla. Ben Armstrong just showed up at an ex-employee's house who he accuses of stealing his Lambo. He decides to bring a weapon and the woman he cheated on his wife with. He also decided to stream it on YouTube with the title Live Streaming from Carlos's House Where My Lamborghini Is. Well, at least he made it clear for law enforcement and the prosecutors that he was there. It's going to be real easy to get the no contact order, the stay away order, the trespassing conviction, which is a misdemeanor, but the stay away order and the no contact order will probably be the biggest part of this. And then those things can become bigger cases criminally if you violate them. But what no one is talking about is the craziest part. Tell us, CoffeeZilla. Ben scheduled the live stream ahead of time, meaning Carlos saw this coming miles away and surprise, surprise, call the police who immediately arrested Ben. Well, good on Carlos. It sounds like he didn't come out of the house. Tuesday, I'm still in disbelief. This is wild shit. The memes are going the Jurassic Park memes. I can't. Okay. I did not see this coming at all. I have covered the legalese is hard, bro, because it was a federal case. There's more that we're going to have to cover. I have some research to do, y'all. How did Bitboy Crypto end up not being Bitboy Crypto? Because it looks like he is no longer Bitboy Crypto on Twitter either. From these posts, it looks like he has changed his Twitter handle. So whatever happened that ousted him from his brand, I am really curious what went down while he's in the middle of these lawsuits because he changed his name to Ben Armstrong. Wait a second. But when you search for Ben Armstrong on whatever we're calling Twitter these days, Twitter is what I'm calling it. Look at this. Look at what comes up. Ben Armstrong's X, Ben Armstrong's F, Ben Armstrong's 2, Ben Armstrong's XI, RX. Are these all fake accounts? That's so strange. Why are there so many? Okay. I'm so... Ben Armstrong Crypto. So he changed his name. Don't call me Bitboy anymore. The influencer formerly known as Bitboy has wake up, hit network employees. Your new boss is a criminal. That's from September 23rd. Today is September 26th. Still doing my first interview with Rice, but I have to hold back for a while due to my lawyer's request. Your lawyer has been drinking Pepto-Bismol, and that's about it. That's it. Vaughn Art, this is a well-taken point. I can't, don't do Prince dirty like that. That's very fair. That's very fair. It's a well-taken point. His lawyer has indigestion over all of this. I'm sorry to whoever these accounts are for what I said yesterday. I've been very upset with things they have chosen to do in this situation. However, it's not worth losing friends over. The fact is, I have so much PTSD from TJ that even a slight feels like a gaping wound. Then don't go live stream from people's houses. And by tomorrow, this was 6 hours ago, and by tomorrow, I meant today because I've been up all night because I am a hardened criminal loiterer. I'm glad to see he's taking it seriously. His lawyer is going to be taking it seriously. In all seriousness, I'll be back on the show tomorrow like normal. I have PTSD from what TJ has done to me. My company has been stolen. I was extorted for my Lambo. I'm angry about all of it, beyond angry. The only thing exceeding the anger is the hurt. Not legal advice, but if you are beyond angry, don't go to the person's house that you're angry at and stream it. It will be interpreted as aggressive. Here's the point, and listen, I understand if some of you won't accept it. I am not getting rid of Cassie, period. My own friends and family lied and manipulated me in the worst ways to accomplish their goal of breaking us up, and I will never give them what they want, never. So me, my wife, and Cassie are trying to figure this out. We are all grown adults capable of making our own decisions, and we don't need any of you to help us with that decision. So please butt out of my personal life as it relates to my relationships. I don't know if the middle of a crisis is a time to determine to have an open relationship, but okay. This is the hardest tweet I've ever had to make. I need to make a confession I never had managed I would admit. I'm not even really sure if I have the courage to say it, but I'm going to do my best. Here it goes. My name is Ben and I'm a loiterer. I did a whole 8 hours in the slammer. So not taking that seriously or understanding why other people would interpret that as a threat. There's a lot of drama in the crypto sphere, it seems. I don't know. Other than a Tuesday, who are the crypto drama channels? This is don't go to people's houses. Don't stream outside of people's houses. Process the big feelings before you process them on the internet. This is fucking wild. Okay. It seems like crypto and the company that owns the Bitboy branding are not in a good spot altogether. And that's wild. I need to know if this is what he was wearing when he was arrested, going live to talk about crypto mostly. I need to know if this Bitcoin horrible week ahead, but why is there hope for crypto? That's not the same stream. Wait. Live. Streamed 1 hour ago. Leaving crypto, what this means going forward. It looks like the other, is this the live stream? Did he change the title of it? I don't know. Maybe, maybe not. Maybe it's down. I don't know. Well, that's some interesting breaking news, law nerds. The crypto world doesn't disappoint. The chat says the stream is taken down. Fair enough. Yeah. Kelver. I read that wrong. Clever one. There we go. Did I hear him correctly? Yes, you did hear him correctly. Yes. If you show up to somebody's house and stream outside of it, and have a weapon in the vehicle, they're likely to take that as a sign of aggression or a threatening act. That's not likely to, well, it's likely to end with them calling the police, which is exactly what happened here. Wow. Well, that's my rabbit hole for the afternoon, guys. But what we need to do is talk about Depp v. Heard and not the crypto going off the rails. I guess we're going to have to check in and see what's going on with the federal case. And if there is a lawsuit with the breakup of this company that he says he's been ousted from, and who started the company. You know, in the Jaclyn Hill situation where Jaclyn Cosmetics, people thought was owned by Jaclyn because she said it was owned by her, but it's really not owned by her. I wonder if this is like that, where the investors really owned the IP and the company. But either way, what we need to do is go do the sidebars. I've been talking about this way too much. Let me figure out what days we're going to do first. Real quick. Wow. So wild. Let me go. What am I doing? I am broken. My brain is broken. What the fuck? What the fuck is happening? I had no idea that this is where this was going to end up. What an unhinged and wild thing. What a strange choice that's going to have legal consequences. And then the statements on Twitter, again, will be used against him. I don't know if that's going to impact him at all. I don't know if he cares. But everything you say on Twitter or X or whatever is going to be used. Okay, here's what the plan is for today. Thanks, chat, for the quick bits. Sidebars did get sidetracked. I don't know. We need the pickle. Hold on. Here's the plan for today. Replay crew. God bless you. You're probably checking in here for the timestamp. We need to finish Amber Heard's cross-examination. We need to do closing arguments. We need to do the TMZ motion and Morgan Tremaine. Those are my main goals. So we need to do that. Okay. Oh, I'm going to knock my hat off. We're going to do it. That's what we're doing with the sidebars. Let me figure out what day of testimony we are going to be checking in with. May 5th, it looks like. Did we get to Amber Heard day 2 the last time? Miguelina, do you mind looking? I know we got to Amber Heard's testimony day 1. I don't know if we finished Amber Heard's testimony or if we just didn't finish the cross-examination. I think we just didn't finish the cross-examination. So let me go look at May 16th. I think that's where we're picking up. All right, let's finish that cross-examination real quick. Swoop. All right. I think May 16 is the day that we're looking for. No. May 16th, Monday, May 16th. I think that will get us into cross-examination, but let me just take a look at the transcript because that's where we are going next. Beginning of the day. This is still direct examination. I'm going to go to the end of the day because I know we finished up with Miss Vasquez at the sidebars for the cross-examination for the beginning. I think it's on this day though. Let me see. Sorry, y'all. My brain is rattled. I'm normally well and better prepared. Just the cross-examination is missing. Thank you, Miguelina. So that's where we need to start. And because we did the direct examination. Let's see. This is Miss Vasquez. All right. So this is resuming. We were in the middle of the witness last evening. We'll continue her testimony. So this is the middle of cross-examination. So I think what we had done is the very first day of Camille Vasquez cross-examination, that half day, and we are now fully into cross-examination by Camille Vasquez on May 18th. Wait, this is not the right one. We need to be on May 17th. Wrong transcript. We need to be on May 17th. All right. Trial day 18 is, I think, where we know. Let's see. Sorry, y'all. I think this is where we need to be. Because we had finished. The last one was Camille requesting if they could bring in the knife. I think we finished the very short part of the beginning cross-examination, and this will be they're arguing about something. This I haven't covered. This is the beginning of the day where they are asking to bring the knife in. Perfect. Thank you, chat. There we are. Maura Lane. Let's get to the beginning of the morning. This is May 17th, 2022, trial day 18. We're going to start there. The court, all right, do we have any preliminary matters before we bring the jury? It says bring in the jury, but whatever. Of course we do. Sidebar. Breda Hoft. These are all from the audio clips. The court, okay, the audio clips. Ms. Breda Hoft. And these are the redacted set of the 700. I think it's 717. The court, the redacted ones, Breda Hoft. And then I would like to revisit the issue, Your Honor. Your Honor may recall, and I have a copy of yesterday's transcript, and I tagged the section that's relevant here. So Your Honor may recall, first of all, I did put Ms. Heard on the stand, and we have that. At 134, she gives the foundation, explains how she put the metadata on there. So we covered that in the direct with regard to the metadata and whether it was redacted or not off a photo that was being shown during testimony. Then Ms. Vasquez says, and this is at page 134, quote, Your Honor, I would just ask the picture be redacted on hearsay grounds. And Your Honor granted that at that point. The court said, uh-huh. Elaine says, then I came back and revisited this. I tried giving the case law that said the metadata was not hearsay, and Your Honor believed at the time there was a foundation issue, but the foundation had been laid. And we don't have an expert that's going to say how she put the metadata on. How Amber Heard put the metadata on. Well, you have to have an expert to lay the foundation, Elaine. In fact, we believe that we should be able to get those in on the foundation /hearsay. If they challenge the legitimacy, then in rebuttal, we have an expert to say those are legitimate photos. Other way, wrong order. But I need to get those in through her. Lawyers. Don't tell the other side what you need. Like this, I need to get those in through her. You need an expert to lay the foundation of how metadata is placed. But if she is placing metadata on something, of course they're going to object that it's hearsay, because you can change the times of things depending on the program. You can change the date of things depending on the program. It just depends on the program. It depends on the device. And that's why you need an expert. But saying, I need this, Your Honor, is not going to work. If they challenge the legitimacy, which they already have, then in rebuttal, we have an expert to say those are legitimate photos. But is the metadata legitimate? It doesn't matter if it's a photo of Amber Heard's face. They're trying to redact the metadata, Elaine. But I need to get those in through her. Well, the photos are in. It's the metadata that's not in. And I believe that I've laid the foundation. Well, the court disagrees. And the only objection is hearsay. No, they objected to foundation too. And I think the case law is quite strong. The court, okay. Ms. Vasquez, I think this is an expert issue, Your Honor, as you indicated. The court, she's saying it's not hearsay, Ms. Vasquez, but there was no foundation laid for how that text got on the photographs. That's not a photograph. It's a photograph of a photograph. Ms. Bretta Hoff, she explained, the court, I'm still going to sustain it this time, okay? On foundation and hearsay, all right? Thank you. Ms. Myers, we do have one other issue. The court, yes. Ms. Myers, so after our late day 2 weeks ago when we went over all the depositions, the court, oh, deposition day. I can hear Judge A being like, oh, deposition day. Dr. Moo, exactly, which is why I think you need an expert. Dr. Moo said tech tip metadata on photos, EXIF data, can easily be changed to be whatever you want. It's just text embedded in the image file. And depending on when these were taken, if they're taken on like an older camera that used to put the date and time on the photo, you just change those in the back of the camera. Like those things can be altered. This is why you need experts. Ms. Myers says the parties agreed on their depositions. They were sent to be spliced. And then after they started coming back, they started unilaterally de-designating additional testimony. We've objected. What we agreed on in court and what was ruled on by the court is what the court said, right? Ms. Myers, we must, the court said, abide by. Ms. Myers said, we agree that we would withdraw materials, but that was sort of when we were in court, had the opportunity to see what they were withdrawing. We could reevaluate our own designations. We were withdrawing. So we would unilaterally designate after the depositions come back, depending on how long they are, because they were, the court said, okay. Ms. Bredehoff said, so they de-designated back with Filati, and Your Honor said about whether you can cut back after Brandon Peterson and establish the two and the house all the way through every single Friday. When we were in and out in the hallway, we both agreed that we could de-designate more later. It's just our designations. Yes, Your Honor, when Your Honor cut us back to 61 hours, we were in huge trouble. Oh, we'll talk about designations later if we even need to. What's more interesting is that they are very flustered about time already, and I'm not surprised. When Your Honor cut us back to 61 hours, we were in huge trouble and we needed to cut a lot of testimony, and that's what we did. We're back to the timing being a huge issue here, where the defense is having to make really difficult strategic choices about what they put in and what they don't put in. So, hi, B, am I loud?
Oh, yeah.
Hey, Dr. B,
Yes.
do you need a Lamborghini as a work vehicle? I heard that's an option.
A Lamborghini is a work vehicle? Absolutely. Detectives used to go to the lab.
So the clock coming into play here, which we see with the defense in choosing not to use all of the different depositions, because we know that there are depositions that they took that they did not use in this trial, and parts of depositions that they did not use. What's so interesting to me is that they chose to play so much of Adam Waldman's testimony. I wonder if they thought it would make Adam Waldman look evasive, because they played a ton of it knowing that they were already in a time crunch. When Your Honor cut us back to 61 hours, we were in huge trouble and we needed to cut a lot of testimony, and that's what we did. And from May 1st through May 10th, we were sending them exactly the same way they did. We would send them to Planet depots saying, please remove these. These are our designations, not theirs. And they had the right to de-designate more if they wanted to. No, they didn't say a word. From May 1st to May 10th, didn't say a word. So now we're having to figure out, or the team Depp is having to figure out what Team Heard cut out. Because at some point, if Team Heard is leaving in certain testimony, Team Depp might be like, yeah, it's fine. But then if Team Heard takes that testimony out, Team Depp might be like, no, we need that testimony back in. We don't want you taking it out. And then Friday night, they say, oh, we object to you unilaterally de-designating. We had already gotten new Splice videos now. They've got the same ones we do. They know exactly what we de-designated. I said, how are you prejudiced by this? It's what we designated. We need to cut because we can't get it all in. We had to cut. We had to cut significantly because otherwise we couldn't get our testimony in with Your Honor's time limitations. Your Honor, the time. The clock was a bigger factor in this trial. That's what's so interesting to me about this argument. The clock is such a big issue in this trial. We knew that watching the trial, but we see that even more now. Is that why Kate Moss didn't have a cross-examination? Exactly why. The clock became a huge issue. It was an issue for Team Depp as well, but a bigger issue for Team Heard. And you saw how flustered in closing Elaine was particularly. I don't think Rottenborn seemed as flustered until the phone alerts all went off. But you could see how flustered Elaine was with their timing issue by the time they got to closing arguments. The clock was a huge, huge issue here, but they knew. They knew going in. Jessica Meyer says, Your Honor, with respect to Miss Filati's deposition, that one was ours that we did early on, and Heard's counsel reached out to us and said, would you agree that we can both de-designate further? In that instance, we said, yes, we agree. We both de-designated. We both told each other what was being de-designated and what we respliced. So took out and respliced. What happens with the ones that we handled 2 Fridays ago, we were exchanging emails saying we're going to de-designate this from the deposition and, vice versa. We came in, we worked through those. The court said, right. So they had a process. We worked through it, and then those were finalized in our view, unless we had an agreement that, we might, to spare our time, we could de-designate further than that. None of the ones that they are sending fall into that category. This is largely unfair. When we were doing the deposition videos in our case in chief, we didn't have the opportunity to ask after, hold on, we need to remove parts of it. They're taking advantage. So Team Depp is not happy the way that Team Heard is cutting some of the depositions. They were in court on Fridays cutting these depositions by agreement. What can come in and what couldn't come in. Tito's Meow asked a great question in the chat. Why is there a time limit set? Shouldn't all evidence be presented to best represent both sides? This is a civil case, not a criminal case. In civil cases, it is not uncommon for judicial economy to have a limit. If the judge didn't put a 61-hour limit on both sides, this trial would have been 15 weeks or could have been 15 weeks long. So the judge is like, I need to know your reasonable amount of time for trying the case, and we are going to try it in that time. The courtroom only has so many times. Civil cases are backed up years that they don't go to court and get heard. So a lot of it is judicial economy saying you have to put this trial This was a 6-week long trial. You have to get it in this time. Each party has this much time. So if one side wastes time, then they're going to run out of time. It's to keep the lawyers from just going all overboard with everything. And it really makes them strategize what they need to prove their case. Silja said this trial might still be going if they didn't have time. Yeah, it probably would be. It probably would be. So, Jackrabbit said, I feel there's probably a fairness element. Both sides can get equal time if there's a time amount set. That's a fair point too. So, Sunny Day said bad time management. I think difficult time management. I would never work well in this environment. I don't have any sense of time at all. This would stress me out as much as it's stressing Elaine out. It would just stress me out. It would so stress me out. This is not an environment I could trial in at all. But there are plenty of people who are like, yeah, I mean, I need 30 minutes to ask these questions. Bretta Hoff says that's just not true. So Jessica Myers is saying they feel that Team Herd is taking advantage. Bretta Hoff said that's just not true. They did it with Filati in the first week, Your Honor. They're not prejudiced. They're not prejudiced by this. This is our testimony. It's like us deciding not to ask the witness certain things. Yeah, but it's not like that though, Elaine, because if you decide not to ask a live witness certain questions, the defense or the other side can ask them in cross-examination. When it's a deposition, there's no chance to ask other questions because you've agreed on it in advance. They're not prejudiced by this. This is our testimony. It's like us deciding not to ask witnesses certain things, and we've been sending to them for 2 full weeks, and we were sending them to them saying, we're de-designating these. You're welcome to de-designate as well. Let us know if you have any issues with what we're doing. Otherwise, we're severely prejudiced, Your Honor. We can't fit it all in. That's the bottom line here. That's what we've done, and we've done it all the way through. The court said, but 2 Fridays ago, you knew we had 61 hours. And Bretta Hoff said, correct, Your Honor, which is when, 2 Fridays ago, we started de-designating, so pulling the testimony. When Your Honor said that, we said, oh my God, we can't fit these all in. We started de-designating. Ms. Myers, the court, 3 Fridays ago, Bretta Hoff said, we've been de-designating since that time. We've been cutting and they've been cutting. And every Friday, every single one of these lawyers here said, we're going to have to cut more. And they said, we will too. And I said, great. Just let us know. That's what we did. We let them know, and we let Planet Depots know we're beyond severely prejudiced because we're not allowed to cut our own designations. We didn't cut theirs. We didn't touch theirs. The court said, so how are you prejudiced by Ms. Myers, who's one of Depp's attorneys, said, so Your Honor, we are not objecting to what was withdrawn 3 Fridays ago. The court said, how are you prejudiced if they cut more now? Jessica Myers said, the issue is what we removed or what we agreed to remove or lock in was based off our understanding of what their designations. And then it looks like Ms. Vasquez jumped in and said, and Your Honor, and Mr. Chu jumped in and said, we knew the limits. And Ms. Bretta Hoff said, we said, if there's any specific ones you have, let us know. They never did that. We've been doing this for 2 weeks, Your Honor. Vasquez said, Your Honor, if I may, wait, why did we all cut off Jessica Myers? What happened? Why did Jessica Myers just get stepped over? Ms. Vasquez said, Your Honor, if I may, you would really, to do this to us when we're trying to prepare for cross-examination and take away attorney resources, they have decided after Your Honor has ruled on these depositions to de-designate further, not in agreement with us. It's not fair. Mr. Rottenborn, they had a 10-day break to prepare for cross-examination. Ms. Bretta Hoff, Your Honor, there's no prejudice to them. Ms. Vasquez, there is. Ben Chu, there is. Ms. Bretta Hoff, give us one designation that we de-designated that somehow that's their prejudice. This is our testimony, Your Honor. Oh my God. Then Jessica Myers jumped in. After we were in court 3 Fridays ago and you marked up our transcripts, we have not sent any further de-designations. They're still fighting over all of this testimony. Here's the fight. That they're all just like, it's not fair. It is fair. It's fine. No, it's not. Here's the problem. when they were cutting down these depositions, what Team Heard or Team Depp agreed to was in context of what was already agreed to. So we believe that this testimony is coming in, so we're okay with that testimony not coming in. But when they start pulling out that testimony, it's like, wait a second, we all agreed on what was getting cut out of these depositions, and now we can't agree because we need to go back and do this or that. Ms. Bredehoff said, Your Honor, actually, I don't agree that we knew from the very beginning. I know Your Honor said in the first week. Oh, wait. Ms. Meyer said they've received some videos back and then they saw the time and then they started slicing more. Ms. Bredehoff said, exactly, we had to because we can't get our case in. We would be severely prejudiced by that. The court said, but you knew from the very beginning. You knew the time. Ms. Bredehoff said, Your Honor, actually, I didn't agree. I don't agree that we knew from the very beginning. I know Your Honor said it in the first week. The court, right. Ms. Bredehoff, we're going to 72 hours, and then Your Honor changed that down to 61. This is our case now, and once we got the time, and in fact, we have suffered a lot. So it looks like the court cut 11 hours. That's a big, big cut. I wonder what happened that the court cut that. No wonder Elaine is frantic about this. But they're all saying all parties knew this in the first week. Remember the Brandon Patterson one, because they wouldn't agree to the authenticity of all those video clips. We had 2 hours and 49 minutes of authenticating each of those, and then they agreed to it just as we were coming in for that. So we've got stuff for 2 hours and 49 minutes. When we got the time estimates, Your Honor, we came back and said, we can't do that. We have to cut, and we did cuts. I'm not hearing any prejudice on our cuts, Your Honor. This isn't any prejudice. It's not like us not asking more questions. And we've said specifically, and we've been doing this for 2 weeks, Your Honor, they didn't say a word until Friday night. And it sounds like that's when the videos came back. And we said, you're welcome to de-designate as well. And if you have any issues with any of our designations, but we cannot get our case on if we use the originals, we had to cut. The court said, I can't require her to use the originals that you based on just because you're doing this all by depositions. It's just a very strange case, but it's their case, their testimony. So I'll allow the de-designations. Let's move on. So by the time we got to Heard's case in chief, they were running out of time. At somewhere they thought they had 72 hours and then it was 61 hours. That's a big difference that they're trying to accommodate for. So they said, we all agreed on what these depots would be. And Team Heard is like, and we don't have enough fucking time, so we're cutting stuff. And Team Depp is like, we relied on you putting this stuff in. And Team Heard's like, it's our case in chief. We get to do what we want to do. And the court's like, look, man, you all agreed they can cut more. That's it. That's it. We're moving on. So in that, the court's like, we can't not let them cut it if they're not going to get their case in. So it's inconvenient to Team Depp, but that's what's happening. So you're going to have to deal with it. Examination by counsel for the plaintiff and counterclaim defendant by Ms. Vasquez. So this is the beginning of the full day of cross-examination of Amber Heard. Your relationship with Mr. Depp began in October 2021, right? That's correct. And you previously testified multiple times under oath that the first year of your relationship with Mr. Depp was one of the best times, right, Ms. Heard? That's correct. You testified that as far as you could tell, Mr. Depp was sober that first year. That's correct. That's what I used to believe. And that first year was magic. Yes, I've always estimated it was about a year. All right. Let's go looking for sidebars, shall we? You guys have heard the testimony, so we don't need to do that next anymore. Let's see. We did that first sidebar. Let's get to the second sidebar. Let's see. Where are we? Page 9. Page 9 on my PDF. Let's see. You remember and you testified to this jury that he didn't have the phone in his hand anymore when he was assaulting me with the bottle? Right. He had a bottle in his hand when he was punching the wall with the phone. This is talking about Australia. He had the phone in his hand. This is talking about the phone in Australia. When he was punching the wall next to my head, he had me by the throat. He did a lot of things that night. Vasquez then says, so you're acknowledging by the sequence, not my words, your words, Ms. Heard, that you testified to this jury that Mr. Depp smashed the phone into smithereens before he assaulted you. That's the sequencing in which you testified, correct? Amber, I never testified to a sequence. I mean, you testified to events that happened in an order. That's a sequence, but okay. Vasquez, okay, keep talking about that sequence. Then on page 4521, starting at line 3, you testified to being bent over backwards on the bar, right? Ms. Bredehoff, Your Honor, may we approach the court? Okay, sidebar. I gave the background so we knew where we were getting into the sidebar. Ms. Bredehoff, the question Ms. Vasquez is asking is not proper impeachment to use. Impeachment means using testimony in this context, using testimony from a different time to show that the person testified differently. So you're impeaching them with their prior testimony. Okay, so this time you said this, and last time you said this. And Elaine's objecting. Elaine said Ms. Vasquez is asking is not a proper impeachment to use. She needs to ask the question and then go to the page and the line and read what was testified to the page. Instead, what she's doing is she's characterizing her interpretation of the testimony. She keeps inserting her own language. That's not proper impeachment. She has to ask the question that's asked here and give a different answer and then go back and impeach her. That's what she's doing. Ms. Vasquez, I'm not impeaching her, first and foremost. Elaine actually laid out the process for impeachment quite well. Thank you, Elaine. She understands the process for impeachment. And Ms. Vasquez is like, that's not what's happening. Ms. Bredehoff said, Ms. Vasquez said, Ms. Bredehoff, I'm not impeaching her. This is the statement of the party opponent. I can use them however I want, and I'm entitled to do that. So we're going through the transcript. These are misheard statements under oath, and I'm using them the way I see fit. Ms. Bredehoff said she's testifying to her own characterizations of what Ms. Heard is testifying to. Okay, first of all, Elaine, what's really funny is that she's now like, no, there's a proper process for impeachment. But when Elaine's doing something, she's like, Your Honor, isn't it just fine? And Camille is like, that's not how any of this works. I'm not impeaching her. These are statements of a party opponent. I'm allowed to bring them in. And Ms. Bredehoff's like, she's testifying to her own characterizations. Elaine, it's cross-examination where the question is the point, and it's exactly what Elaine did on cross-examination. So it's just... She's used the word sequence. I can't tell how many times. There's no word sequence in here, Your Honor. The court. You can ask the questions and you can use, I understand, you can ask the question, just don't comment on the answer. Ms. Vasquez, okay. I mean, it's cross-examination. The court, I would appreciate that. Ms. Vasquez, okay, thank you, Your Honor. You want to talk about somebody commenting on the answers, Elaine? That's literally your entire process of questioning. Your entire process of questioning is giving commentary to the thing you just asked. But all right. We're now on page 10. Let's get to the next sidebar. On page 16, look, we got 6 pages. Let's see where we are contextually. You weren't able to change, were you, Miss Heard? I very much wanted to leave the relationship I was in, but I didn't have the power. I didn't feel I had the power to leave. I knew I was in a very toxic relationship with Johnny. I knew I needed to change that. I knew it was at this point horrible for me, and I talked to my therapist often about that. Ms. Vasquez, I'm going to move to admit exhibit, defendant's exhibit 371 as redacted with just Ms. Heard's messages. The court, all right. Ms. Bredehoff, Your Honor, I object because she has left out the next two lines from Ms. Heard that clarify even further. And I also think, Ms. Vasquez, Ms. Bredehoff, may we please approach with this? Because Ms. Bredehoff is now giving an argument in front of the jury. Sidebar. Ms. Vasquez, I'm going to ask, Your Honor, that Ms. Bredehoff, the court, I just need, what's your legal objection, Ms. Bredehoff? I can't have talking objections. Ms. Bredehoff, I'm sorry. I think if you look at the redacted, the court, you're saying they redacted more of her statements? Ms. Bredehoff, yes, they did not. She's got more in here. What is the legal grounds, Elaine? Not just like, I'm mad you redacted it. What is the legal grounds? Is this completeness? What is happening? Yes, they did not. She's got more in here. Right. Ms. Bredehoff, that gives the context of this. Oh, you're trying to argue completeness. They're trying to take it out of context and just put these three in. Right after that, she has two more, but she also has the ones before that and the ones that have Dr. Cohen responding to it. Ms. Vasquez, Your Honor, she's able to, the court, but this is their evidence. This is not Ms. Bredehoff. Ms. Bredehoff, when we were objecting, when it was in their case in chief, they were able to put context in, Your Honor. The court, you didn't object to having in the context. You didn't object to them having the context. Oh, Elaine. The court's like, they got to do it. And the court's like, you didn't object. If you object, I can rule on it. And Ms. Bredehoff goes, actually, we did. The court, no, you did not. Ooh. Yeah. Ms. Vasquez, Your Honor, hey, Camille, don't pipe in at this point. Let them fight. Nope, let them out. Camille, let them fight. No, at that point, until they're done, you just real hard to do in the moment, though. It's real hard to sit down and shut the fuck up in the moment because she's still trying to finish the sidebar. But when the court and Elaine are going at it, it's just like, the court, do you have any objection to the context coming in? Ms. Vasquez, it's our evidence. We would just like the text messages that I read into the record that Ms. Heard has testified to are her texts. That's it. I'm trying to make this as easy as possible for the court and Ms. Bredehoff by redacting the hearsay, trying to be respectful of the court's time and the jury's time. And she is purposely interrupting the flow of this examination, and she's making argument. Oh, Camille's pissed. It did feel like Elaine was trying to trip up the cross-examination. However, that is also a valid strategy. That's exactly what Elaine was doing. But also that's not improper. So if you have a valid legal objection, the making argument to the jury in the middle of cross-examination, that part's improper. The court says she's got a valid objection. That's fine. Ms. Bredehoff, the next two are the same part of that. Same one, Your Honor. She's saying, Ms. Vasquez, clearly I can't, Ms. Bredehoff. Ms. Bredehoff, she wants to keep that out, but that's part of the exact same text exchange. The court, on direct, redirect, if you want to put that in there, I don't know if that adds to your case, but if you want to put that in on redirect, you can redirect on it, okay? Ms. Bredehoff, thank you, Your Honor. Back to court. Oh my. All right, let's go to the next sidebar. That was page 17. We're in 4 of 27. And we are on page 18. You know what a deposition is, right, Ms. Heard? I've had several, yes. So you know when someone provides testimony under oath. So you know it's when somebody provides testimony under oath. That is correct. You are aware Ms. Lloyd was deposed in connection with this case, correct? That's true. And Ms. Lloyd's deposition testimony was played earlier in this trial, right? Ms. Bredehoff, I'm going to object, Your Honor. May we approach? Also, you don't have to say I'm going to object. You can just say objection. and then state the legal grounds for the objection. Like that, the preferred method would be objection, hearsay. Objection lacks foundation. Ms. Bredehoft, you cannot impeach somebody else's testimony. We have to impeach with them that witness's testimony. She's testifying to what Ms. Lloyd testified to, attempting to impeach her, and that's improper. Ms. Vasquez, I'm not impeaching her with this testimony. I'm stating what statements have been made in court. The court during this trial. Ms. Vasquez, during this trial. Ms. Bredehoft, and that's hearsay. Shut the fuck up.
Shut the fuck up! Did she just call the in-court testimony hearsay? Stop! Stop it! Stop it right now! Stop! I can't! This party was sitting in court with the sworn testimony. That's the antithesis of hearsay. What is happening? No! Miss Bredehoft, and that's hearsay. No, Elaine.
It's trial testimony. Oh my God. Where's my goat? Oh my God. I have 700 cups. That one's coming to the merch shop. Where is my goat? Damn it. I need to text Judge Abby. I need to be like, Your Honor, how do you explain to a lawyer that an in-court sworn statement is not hearsay? Oh my God. Oh my God. Law students. Hey, law students, ask your professors this. See if their heads explode. The court. Camille says, I'm stating what statements have been made in court. And the court says, during this trial. And Ms. Vasquez says, during this trial. And Ms. Bredehoft said, and that's hearsay for her to testify to what she says someone else testified. The court says, that's not. Elaine, oh gosh. If you are going to be a litigator, the hearsay rules are your art. They are your craft. The rules of evidence are the number one thing you need to know inside and out. With tabs and annotations, you wield them as your sword and your shield. This is how you do battle in a court of law, with the rules of evidence. And the lack of understanding for some of the basic rules of evidence, the basic and fundamental, not basic and lacking complexity. They are complex. But once you start working with them in court as a litigator, you start to understand. But Karen Smith in the chat pointed out exactly where we're at. This is it. This is the correct response, Karen. Catherine, I'm sorry. Catherine, apologies. This is the correct response. Legalese is hard, bro. Like that's the only option at this point. And is Elaine fucking with us? Because Elaine's like, this is how you properly impeach someone. Uh-huh. And then she's like, but Your Honor, that's hearsay. Are you fucking with me? Because I'm wondering if this is the strategy of like, no, I'm just a simple country lawyer. Because it's extreporous at this point. But I wonder if this is a strategy at this point. But what, Your Honor? Just in case it works. I don't know. Is this strategic? Hold on. I need my comfort rules of evidence. Hold on. Where are they? All of them. Come here. Look. Here's the thing. I saw a meme the other day. Not about the Roman Empire. And it said that lawyers are basically attack librarians. I can't even say it. I'm going to snort. Oh my God. It basically said, you know, lawyers are attack librarians, which is true. Lawyers use books. They use case law. They use research. They use rules. And they use those rules to their advantage and their opponent's disadvantage. This is the federal rules of evidence that you might want to carry into court. Look, if you're in a particular state, you might just want to have the one for your state. This is it. This is all. You've got a nice, concise treaty of all of your rules. All of it. All of it. And you can just get to where you need to be. But also, this just goes into court with you all the fucking time. All the fucking time. This is your life. This is your life when you need to study. The annotated rules tell you everything you need to know. It's just in there. This has the case law, key case law for your rules of evidence. It's so easy. I mean, it's not easy if you haven't been through law school, but once you've been through law school, this is your world as a litigator. This is it. Hold on. We're just we're just going to go to hearsay real quick. And then we're going to just read the definition all together so I feel like we're all on the same page. And then that's it. Definitions that apply to this article, exclusions from hearsay. We don't need those. Hearsay. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearing. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and a party offers an evidence to prove the truth of a matter asserted in the statement. This is why I needed to give you all the background so you all could feel it with me. Statements that are not hearsay. And then there is a page of statements that are not hearsay and why they're not hearsay. Those are the hearsay exceptions. The rule against hearsay, Rule 802. Hearsay is not admissible unless any of the following provides otherwise: a federal statute, these rules, or other rules prescribed by the Supreme Court. If it meets the definition, it doesn't come in unless there is a rule that says it can come in. And then there's rules of the exceptions to hearsay under 803. Past sense impression, excited utterance. Law school was fun with declaring what was not an excited utterance. Then existing mental, emotional, or physical condition. Ow, I've hurt my elbow. Is a then existing mental, emotional, or physical condition. There are other things that can count. Statement made for medical diagnosis or treatment. Why are you here today? I've been shot. Recorded recollection. Records of a regularly conducted activity. Those are going to get into your business records. Absence of a record that regularly conducted activity. Public records of vital statistic. Absence of a public record. Records of religious organizations concerning personal or family history. Certificates of marriage, baptism, or similar ceremonies. Family records. How do you know your name? It's hearsay. Someone had to tell you. No. Records of documents that affect the interest in property. Deeds, trusts. Statements and documents that affect the interest in property. Statements in ancient documents. Market reports or similar commercial publications. On and on and on. Sorry. Okay. Let's keep going. Let's continue on. We've gotten the point. I've belabored it too much. Apologies. Ms. Bredehoff, and that's hearsay for her to testify to what she says somebody else testified. The court, that's not. I'll overrule it. Ms. Vasquez, so in a deposition, Ms. Heard, you know it's when someone provides testimony under oath, right? That's correct. You were aware that Ms. Lloyd was deposed in connection with this case. That's correct. And Ms. Lloyd's deposition testimony was played earlier in this trial. Yes. So you heard Ms. Lloyd testify under oath that Mr. Depp never threw a can of Red Bull at her. I can't remember if she didn't. If she didn't recall that, or if she said it didn't happen, I don't remember. I vaguely sense she didn't recall anything. Okay. Next sidebar. That was page 19. This is page 20. Let's see. You wrote each other messages in a journal. In that journal, right? That is true. Ms. Vasquez, if we could please pull up Plaintiff's Exhibit 91. I'm going to be showing you portions of this. So if we could please call this Plaintiff's Exhibit 91A. This is the journal that you and Mr. Depp kept with each other in electronic form, correct? That is correct. Ms. Vasquez, if you could scroll through, these are entries you made in the journal, correct? Is it done? Yes. Ms. Vasquez, I'm going to move for the admission of Plaintiff's Exhibit 91A. And I've gone ahead and redacted Mr. Depp's writings as on hearsay grounds. So at this point, Camille is trying to remember, if you lose the sidebar, the time goes against you. Ms. Bredehoff, I'm going to object, Your Honor. May we approach? Okay. I can imagine the court's like, okay. Ms. Bredehoff, Your Honor, I'm going to object on the basis of Rule 2106. When part of a writing or record, you could just say completeness when she must have something in front of her that she's reading. When part of a writing or record or recorded statement is introduced by a party upon motion by the other party, the court may require the offering party to introduce the other part of the writing or recorded statement, which ought, in fairness, to be considered contemporaneously with it, unless such additional portions are inadmissible under the rules of evidence. The court is like, which would be inadmissible hearsay. Which would be inadmissible hearsay. Unless portions are inadmissible under the rules of evidence. And the court's like, right, hearsay is the rules of evidence. Ms. Bredehoff, well, I don't know. I mean, I didn't have an opportunity to see which ones she's going to move. The court, she's putting in Ms. Heard's statements, not Mr. Depp's statements. The court, keep up. Ms. Bredehoff, but is she doing all of Ms. Heard's statements or just one? Oh, I think this is a strategic slowdown. Ms. Bredehoff, but is she doing all of Ms. Heard's statements or just one? Ms. Vasquez, some of them. The court, some of them. Ms. Bredehoff, then I would like to see if, in fairness, others of Ms. Heard's should be in there as well. The court, I'll overrule the objection. There wasn't even a legal grounds for the objection. It was just, Your Honor, can we have a chat? Ms. Bredehoff, may we be told which pages? The court, can you tell her which pages? Ms. Vasquez, yes. Ms. Bredehoff, will we know that before? Ms. Vasquez, I'm going to go through it as we go through it. The court, could you just tell her? Ms. Vasquez shouldn't have to. Ms. Vasquez, I'll call them out. Could you just let her know before you go through it which pages they are? Ms. Vasquez, sure. Ms. Vasquez, let's start with the first page. It's the picture. Ms. Bredehoff, Your Honor, they haven't given me the pages yet. Oh my God. Ms. Bredehoff, Your Honor, they haven't given me the pages yet. The court, can you tell them which page numbers they are? Ms. Vasquez, I'm writing them down. The court, okay, let's write them down first. Sorry, Judy, let's write them down first. Ms. Bredehoff, thank you. Ms. Vasquez, if we could please publish this to the jury. Let's get on to the next sidebar. Your Honor, make them tell me the pages. We are now skipping to page 30. This is the wedding. You arranged to have drugs at your wedding, correct? Like I said, we had mushrooms. We had mushrooms on for my bridal party beforehand. On the island for your wedding. Before the wedding. On the island, yeah. Ms. Vasquez, can we please pull up Plaintiff's Exhibit 1262? This is an email you sent on February 1st, 2015, correct? That is correct. Yes, that's correct. Okay. I'm going to move to admit and publish Plaintiff's Exhibit 1262. The court, any objection, Ms. Bredehoff? Yes, Your Honor. May we approach the court? Sure. The court will get you down with that microphone eventually. It sounds like Elaine's microphone was not on when the court was like, any objection, and then was staring at Elaine, and Elaine was probably doing something with her face. And then the court said, we'll get you down with that microphone eventually. Ms. Bredehoff, it turns off and it's on its own, Your Honor. I put it on and then I don't realize it's off. The court, I don't think so. The court, Elaine, your mic. No. Ms. Bredehoff, I have to object more often so it stays on. Jesus, that's not the response. The court, all right, what's your objection? Ms. Bredehoff's trying to be cheeky with the court at this point. It's too far gone. The court's not amused. Ms. Bredehoff, this was produced after. This is not in the exhibits that defendants have. Ms. Vasquez, I don't think that's true. Ms. Bredehoff, 1262, which was not in their trial exhibits. The court, is it in your evidence? Ms. Vasquez, well, nevertheless, this is an email from Ms. Heard. I'm not certain that that's true. First and foremost. Second of all, this is an email from Ms. Heard. The court, okay. Ms. Vasquez, and I can use her statements after the fact. The court, all right. Ms. Bredehoff, but it's not for impeachment purposes. The court, is it a plaintiff's? Ms. Vasquez, plaintiff's, yes. Ms. Bredehoff, it should have been provided in discovery, Your Honor. We produced our exhibits. Ms. Vasquez, it's not direct examination. Ms. Bredehoff, but it's not impeachment. And there's nothing about it that's impeachment. Interesting. Ms. Vasquez says, it is. It's her statement. It's an email. She just testified. I laid the foundation, and frankly, Ms. Heard should have produced this. This is her email, Ms. Bredehoff. She should have produced it. Ms. Bredehoff, this was produced in discovery. This was in discovery. She was asked about it in the UK, Your Honor. Ms. Vasquez, so it was produced in discovery. So what's the objection? Like the circular argument here that Elaine caught herself in. It's your client's email. It was used in the UK. So what's the problem? So it was produced in discovery. So what's the objection? Elaine is snappy. The court, what's your objection, Ms. Bredehoff? Because it's not a trial exhibit. But it's cross-examination. Because it was not a trial exhibit. That's what we got objected to. The court, I think it's Exhibit A is in Exhibit. Ms. Bredehoff, it's not one of our exhibits. Ms. Vasquez, it has a Bates number. It was produced in discovery and it's my exhibit. Ms. Bredehoff, it's not a trial exhibit. The court, it's cross-examination. Ms. Bredehoff, but it's not impeachment. There's nothing that impeaches her. The court's like, we're not going round and round. I'll overrule the objection. Elaine is trying to say you can't get it in. Camille is saying it's cross-examination. I can cross-examine her on her own statements. This is a statement. It's not hearsay because it's a party opponent. And it's just like, okay, what's in the fucking email? This is a schedule. Oh, I loved this part. This was funny. I was not expecting this at trial. This is a schedule for your wedding weekend, right, Miss Heard? No, it's not. It's a proposed draft of a schedule. It ended up being quite different. Okay. Do you see where it says 7 p.m. rehearsal dinner? Yes, I see that. Next item on the list says after dance party and drugs and music, right? That is correct. So you plan to have drugs at your wedding to someone you characterize as a drug addict. To be fair, we were both to have separate parties, as I mentioned. So a bridal party before this, the schedule ended up changing quite a bit. And this is a draft, clearly, that was sent before there were a lot of changes made. The bridal party question. So your original idea, Miss Heard, your original idea was to have a rehearsal dinner with your husband, the drug addict, the monster, and do drugs with your girlfriends on the island after your rehearsal dinner. I realize that the email suggests, but it's not what it suggests, Miss Heard. It's what you said in the email. Amber, right. But what I'm trying to say is that schedule ended up changing. We ended up doing the little indiscernible due to cross-talking. Ooh. Who's cross-talking? Probably Camille's. Question. So your original idea was to do drugs. Original idea was to do drugs on an island after your rehearsal dinner to the drug-fueled monster you were about to marry, right? Answer. As the email suggests, there was going to be weed on the island. This does not reference the cuddle puddle that I just referenced to you. Oh, we're at the cuddle puddle part. McGee P said in the chat, cuddle sidebars equal lawyer cuddle puddle. Less friendly lawyer cuddle puddle. You like to do drugs on special occasions, right, Miss Heard? I have before. And you did drugs again for your 30th birthday, right? That's correct. That was a huge mistake. So this is back to Camille trying to prove the point that I think the point Camille's trying to make on Cross is that Amber was so worried about Johnny Depp's drug use that it was on their wedding plans that there would be drug use. All right, we're now only on page 32. Let's see. Okay, let's look at Plaintiff's Exhibit 1263. Ms. Bredehoff, Your Honor, I'm going to ask to show, first of all, this one hasn't been produced. This has not, it's a brand new trial exhibit. It's cross-examination. So I don't have it. I would like an unredacted copy, and then I would like an unredacted copy to be shown to the witness. The court, do you have an unredacted copy? Ms. Vasquez, we can make one, Your Honor. The court, okay. Ms. Vasquez, Your Honor, may we approach about this? The court, all right. Ms. Bredehoff. Ms. Bredehoff, oh, I'm sorry. Was Elaine not paying attention that they all went up to sidebar without her? Ms. Vasquez, Your Honor has already overruled Ms. Bredehoff's objection that it's not on our exhibit list because that's not a legal objection. The court, I know, for cross-examination, you did it too. We entered new evidence for your cross-examination. Ms. Bredehoff, Your Honor didn't allow any of our new evidence in. The court said, no, that's not true. Ms. Vasquez, cross-examination. The court, here's all the 1804, 1558. Ms. Bredehoff, those were pictures from Ben King, Your Honor. That's the only one we were able to allow in. And that's because they didn't produce them in discovery. Ms. Vasquez, cross-examination doesn't have to be on the exhibit list. It says exhibit, but whatever. Ms. Bredehoff, they have to give us an unredacted copy so we can see it. The court, I understand now, but it doesn't have to be on their exhibit list to have cross-examination. You agree with that, right? The court is trying to go back to like the basic trial functions. Elaine, you understand that cross-examination is different than direct examination. And things can come up in cross-examination that don't have to be disclosed. And so the court's like, you agree with that, right? Like the court is trying to check in with Elaine that Elaine also agrees with these basic principles of like trial. And Ms. Bredehoff said, well, it depends. Erroneous. I mean, unless it's barred by other rules of evidence, I guess then it would depend. Ms. Bredehoff, well, it depends. I think it depends on the circumstance, Your Honor. Cross-examination just doesn't, if it's for impeachment purposes and rebuttal purposes, yes. Well, no, actually. It has to not be otherwise objectionable. It can't lack foundation. It can't be hearsay. But it can come in on cross-examination even if it's not disclosed to you in the trial exhibitees list. The scheduling order was quite clear. If it's not on your exhibit list and it's not for impeachment, it's not permitted in. It depends upon whether it's for impeachment or rebuttal. The court, well, we're past that. Ms. Bredehoff, I don't know what this document is. The court, if you need to see it, but they need to see it they need to see the unredacted part, which is fair. If you are going to use an exhibit on cross-examination, the other side should be provided with it so they can see what the full exhibit is, even if that's not what's going to the jury. Ms. Vasquez, the only thing redacted, Your Honor, is I'm going to show her one text message. The only thing redacted is personal identifiers. The court, there's a whole chunk there. I just don't know what's there. Ms. Vasquez says there's text messages from other people. I was trying to make things a little easier. This is how Ms. Bredehoff produced her text messages. So it has text messages from a bunch of people. The court, is there something that was supplied? Is there something that was supplied to you from them? Ms. Vasquez, yes. The court, do you have it in discovery? Ms. Vasquez, it's there. I mean, this is how Ms. Heard produced her text messages. Okay, so keep reading, Emily. Camille is saying, Your Honor, I don't know if we have an unredacted because this is produced by them in discovery. So Elaine is objecting to an exhibit that they are using in cross-examination that she produced in discovery to Team Depp. Oh my God. Okay. It's there. I mean, this is how Ms. Heard produced her text messages. Ms. Bredehoff said, we gave copies to them of everything we had, Your Honor. They're now not giving us copies, but then they're giving us copies of redactions. We need to be able to look at it. The court said, I agree. Ms. Vasquez says it's just a text message. The only thing redacted is it's one text message that I would like to present. It's hers. The court said, I understand, but they're entitled to see the unredacted page. Ms. Vasquez says, okay. The court says, so if you don't have that now, maybe you can try later. Ms. Vasquez said, I have it. We can show it to her. But it seems like they're arguing over stuff Elaine produced. These are text messages that Heard produced to them. The court said, okay, just show her that. Ms. Vasquez, thank you. Okay. Ms. Bredehoff, thank you, Your Honor. This is why shit needs to be bait stamped if it's turned over. So that Camille could just say it's bait stamp number whatever. And then Elaine can flip through her book and just be like, oh, there's the unredacted version. Ms. Vasquez, I'm going to show the unredacted message to counsel for Ms. Heard on the laptop because I don't have a hard copy. The court, okay. Ms. Bredehoff, let's just approach for a minute. Is this the next sidebar? The court, what's that? Ms. Bredehoff, during the lunch break, Your Honor, can they give us hard copies? So at least I'm not asking them to give it to me in advance. But if they don't have hard copies, at least during the lunch break, the court, they'll get you hard copies for the ones at lunchtime moving forward. Ms. Bredehoff, moving forward. The court, moving forward. Ms. Bredehoff, that's fine. And then hard copies of whatever they can't give me now. The court, right. You'll just look at the laptop. Ms. Bredehoff, I understand that. Ms. Vasquez will produce it. Ms. Bredehoff, but at the lunch break, if they can give it to me, the hard copies, the court, that's fine. At lunchtime, okay. Ms. Bredehoff, thank you. Open court. Ms. Vasquez, here you go. So Ms. Heard. Ms. Bredehoff, Your Honor, I'm going to object to asking questions while I'm looking at this. The court, if you could give her a moment, please. Ms. Vasquez, sure. Fine. The court, thank you. Okay, Ms. Vasquez, thank you, Your Honor. The court, all right. Thank you, Ms. Vasquez. Okay, the court, any objection? No, Your Honor. All right, thank you. This is a text message that you sent Mr. Depp, correct? That's correct. And you sent this message, and you sent this message to Mr. Depp the day you had your 30th birthday dinner, correct? That's correct. And you write, hey, baby, bring up something to drink and or a joint. I'm in. If you are, see you in a minute, XX. Did I read that right? Yes, Ms. Vasquez, you continued to read it correctly. That is correct. And then the next day, you went to Coachella and consumed MDMA and mushrooms, right, Ms. Heard? I did. Johnny was not there for that. Okay. Let's talk about the 30th birthday. So now we're at the 30th birthday. Let's see what context this is. The day after your birthday dinner, you and your friends went to Coachella to celebrate your birthday. Is that correct? Yes. You made a video driving out to Coachella with your friends, didn't you? That's correct. I would like to pull up plaintiff's exhibit. Okay. That's where we come up for the sidebar. So we have an audio tape. That's a brand new exhibit. Ms. Vasquez, video. Ms. Bredehoff, video? And I'd like to see it before she shows it to the jury. Oh, this is from social media. Ms. Vasquez, can we play it for the witness and counsel without sound? And then you can publish it to the jury. The only sound is the music, so it doesn't have any lyrics. The court, all right, you want to view it Just for the witness and counsel? Sure, thank you. Any objection? No. And then the video is played. This is the video you made when you drove to Coachella with your friends. That's correct. I'm not quite sure which one of us made the video, but that's correct. You're featured in the video, correct. And it's set to the song Miss You by the Rolling Stones. That's correct. That was a message for Mr. Depp, wasn't it? No, that's ridiculous. And then they talk about drugs at Coachella. Wait, what happened? It went back to 1. We were not done yet. Sigh. Thanks, Google. Hold on. Sorry, y'all. Let's see. What number were we on? I need to start calling them out. We were, hopefully, let's see if we can find Coachella again. Okay, orchestrated smear campaign. We weren't there yet. Let's see. Okay, this is where we were. 9, 10. They're talking about the officers. I saw her testimony. Yes, you heard Officer Sands testify that she did not see any injuries on you that night, correct? I heard her testify that she did not consider this injured. No, Officer Sands testified that she met with you and she did not see any injuries on your face. Is that correct? She did not consider this injury. Ms. Heard, my question is a bit more nuanced. Ms. Bredehoff, Your Honor. Ms. Heard, so is my answer. Ms. Bredehoff, may I approach the court? All right. The court, what's the objection? Ms. Bredehoff, again, she's reciting other people's testimony, which Ms. Bredehoff, her version of these can do. The court is saying, which she can do. What Ms. Bredehoff is not saying is objection misstates testimony. Because I don't think at this point Elaine understands misstates testimony as the proper formulation for that objection. But also I think she's trying to slow down the testimony or the cross-examination that hurts Amber Heard, but it makes it look like she's trying to bail out Amber Heard. What's the objection? Again, she's reciting other people's testimony, her version of these, the court, which she can do. Ms. Bredehoff, Ms. Heard is responding exactly correct. I wonder if Amber could hear her saying that. Ms. Heard is responding exactly correct. Officer Sains said she didn't consider that an injury, that that was when she was seeing the picture. But her original testimony is the deposition we played was that she said she didn't see any injuries. You showed her a picture. She said she didn't consider that an injury. Ms. Vasquez, 2 different things. Ms. Bredehoff, that's just improper cross-examination. No, that's good cross-examination. That's exactly proper cross-examination. Elaine is trying to conflate the 2 testimonies and say that the testimony that she finds more specific and helpful to them is the only testimony. And the court, after paying attention to this trial and hearing all the testimony, said, no, those are 2 different things. Ms. Bredehoff, it's just improper cross-examination. The court, it's not improper. It's not an out-of-court statement. It's an in-court statement. Ooh, that could be said a lot of ways from the court. The court, it is not improper. It's not an out-of-court statement. It's an in-court statement. Though I could hear the court screaming this, because in my brain, I am screaming. Ms. Bredehoff, it's Ms. Vasquez testifying to what that woman testified to. It's hearsay.
Elaine, boo-boo, this is how cross-examination works. See, you're allowed to use things that happened in trial and then ask about them. See, and the court is not going to continue to suffer this type of bullshit at sidebar. This is fucking wild. It's Miss Vasquez testifying to what that woman testified testified to. It's hearsay.
Hold on. Let me get back to Rule 802 real quick. Let's get back to the definition of here. Let's get back to the definition of hearsay. The court should have just started reading the book. The court was too fucking tired and put out to start reading the rules. But hearsay means a statement that the declarant does not make while testifying at the current trial or hearing. So calling testimony hearsay is the stupidest shit I have ever seen. How do you even explain it? It's like that scene in Clueless. It's like, she's talking about some garden party. The court, it's not hearsay. I've sustained this over and over. And for the record, you can have an ongoing objection. Elaine objects. Objection, Your Honor. Effective cross-examination. Ms. Bredehoff, thank you. This is so dumb. The court overruled. Ms. Bredehoff, this time, in addition to that objection, Ms. Heard is correctly characterizing what Officer Sands testified to. Ms. Vasquez, no, she's not. The court, no. I just told you that was two different statements made by the officer, and on redirect, you get to come up and say exactly what happened, Ms. Bredehoff, okay? But please, also, don't be so animated when you lose an objection. Last time you left here, Ms. Bredehoff, I apologize. I caught myself right after it. The court said, I almost brought you right back. Ms. Bredehoff, I apologize. I did not mean to do that, and you're right. I should not have done that. The court, I will call you back next time. Don't do it again. Ms. Bredehoff, I won't. Ms. Vasquez, thank you, Your Honor. Yeah, Ms. Bredehoff had like a temper tantrum when she lost her objection and was just like, she kept doing that. Ms. Vasquez, Tom, can we put these down, please? I think they might be confusing the witness. I think they're confusing Ms. Bredehoff. Ms. Vasquez, my question is more nuanced. You sat in this courtroom where Officer Sands testified that she saw you the night of May 21st, 2016, face to face and didn't see any injuries on your face. Isn't that correct, Ms. Heard? I believe she was testifying about those photographs and she said I was not injured in them. It's your testimony under oath now that Officer Sands testified that she saw injuries on you when she saw you in person on May 21st. Sorry, let me clarify. I was testifying that I know that that's what Officer Sands said, that she said she didn't consider my red puffy face injured. That's what she said. The red puffy face, that was your counsel's question, correct? That was her testimony in the UK. She said that's incorrect, and you know that, Ms. Heard. I disagree. Just inconvenient for you that Officer Sands didn't see any injuries on you on May 21st, 2016. Doesn't matter what's convenient for me. And then they fight about this some more. They went round and round and round in this cross-examination. That was page 48. We're now on page 56. Amber Heard says there's been an ongoing smear campaign. Yes, an ongoing negative publicity campaign, an orchestrated smear campaign. You have no evidence of that, do you, Ms. Heard? Look me up. You'll see. Let's take a look at some of that. Ms. Vasquez, Your Honor, may I approach the court? All right. Sidebar. The court, okay, the articles, Ms. Vasquez, the articles. The court, okay, Ms. Vasquez. So obviously there's a copy for you, Your Honor. The court, sure. So I plan to do the same thing with these, Your Honor. Ms. Bredehoff, these are all new exhibits at this point, Ms. Heard, to Ms. Heard. Wait, these are all new exhibits that point to Ms. Heard. There can't possibly be a reason why they wouldn't have to put them in the trial exhibits before. They knew she was going to be making these claims. Well, then so did you, Ms. Vasquez. This is exactly what Mr. Rottenborn did during cross-examination of Mr. Depp, and they're not going to be admitted into evidence. I just plan to read the headlines. The court, read the titles, the headlines, like he did. Ms. Vasquez, there you go. Ms. Bredehoff, first of all, Your Honor.
Let me just put on the record, it is not correct. That's exactly what Mr. Rottenborn did. Those were in our trial exhibits. In fact, they're in the very first part of our trial exhibits. Were all of those. So I don't have an ongoing objection to using anything that wasn't put into evidence as part of the trial exhibits. They knew she had a counterclaim. They should have had it as a defense, part of the exhibits.
The court, I understand your observation. Again, it's cross-examination. I'll allow them. I want to give you an opportunity. You're not going into the text of the articles, just talking about the titles and date. Ms. Vasquez said, I plan to read the title, and then I'm not going to be admitting them into evidence. The court said, not into evidence. Ms. Bredehoff will need copies. The court, you'll get those copies. Ms. Vasquez, I'll get them copies. The court, are you saying all of these are for the 3 statements? Ms. Vasquez, yes. The court, okay. Ms. Vasquez, there you go. Your Honor, I have a question. Yes, Elaine, of course you do. It feels like everybody's on the same page, and then Elaine's like, what? What happened? The court, sure. Ms. Bredehoff, if we can look at 1272 for a moment, that's May 29th, 2020, which is after 2 of the court. I'm sorry, I'm having trouble hearing you. Ms. Bredehoff, oh, I'm sorry. The court, that won't help me. I appreciate it. That's not me. That's Judy. Which one? Ms. Bredehoff, if you look at 1272, the date's May 29th, 2020. I'm obviously seeing these for the first time, Your Honor, so I'm trying to go through them. The court, remind me again. Ms. Bredehoff, 2 of the April 8th, April 28th, and the court June 24th, laminated. It helps me. So that May 2020 would be after 2 statements. Ms. Vasquez, that's right, Your Honor. And I think for relevance, Ms. Bredehoff's objection is that they're not being cited in the title to Mr. Waldman's statement. It's talking about another allegation that was out in the press. So for Ms. Heard to allege that Mr. Waldman's statements caused her to lose opportunities, and there's articles before and after that were in the press, and I think we have to argue that, Your Honor. Ms. Bredehoff, so Your Honor, I'm trying to keep up, Your Honor. The court, that's all right. Take your time. Because she's now trying to flip through the articles. Ms. Bredehoff, this last one is 1273, Your Honor. I don't see a date on it. The court, 1273, I don't see a date either. Ms. Vasquez, May 24th, 2020. The court, yes, so we'll take out 1273. I'll sustain the objection to 1273. Ms. Bredehoff, Your Honor, I would object to 1274 too, and that title. I think it's not a reputational issue for her if somebody makes an allegation about her having an affair. I don't think it's appropriate. I don't think it's, the court said, yeah, okay, all right. Ms. Vasquez says, I mean, we just admitted evidence today about her having an affair with James Franco the night after April 21st. So these are all allegations. Ms. Bredehoff, it's not an allegation. The court, I'll take the objection on this one. All right. I don't know what the court means by that. I'd be like, what do you mean I'll take the objection? Is that sustained? Is there any more than that? Ms. Bredehoff, this is after 3 articles. The court, this is after all 3 articles. Ms. Vasquez, Your Honor, again, it's surrounding about the statements that they were. The court, so you're saying you're not offering just for her reputation before, you're offering for her reputation after as well. That affects her reputation. Ms. Bredehoff, I think that opens up the door, Your Honor, to the UK judgment. I think she gets, if she opens up the door. The court, she's doing damages. She has a limit to her damages. She's starting her damages after 2020, correct? Ms. Bredehoff, Your Honor, this one is testimony from the trial that says Amber Heard stole my sexual assault story. Ex-aide tells libel trial. The court, right. We had a lot of testimony from the UK. I feel like I've been at the UK trial. I don't see how that would open any door. That's funny. The court's like, right. I feel like I've lived there. The court's like, I traveled to the UK and I didn't even know it. Didn't get a stamp on my passport or anything. Ms. Vasquez says it's public knowledge, Your Honor. Ms. Bredehoff, I don't think that it's an appropriate one. Again, she's testifying. Ms. Vasquez, she testified here. The court, just the headlines to talk about reputation. That's out in public about her reputation. I mean, I did about 25 on Mr. Depp and all kinds of different issues of reputation. I think that goes to damages. Any other ones? Ms. Vasquez, sorry, Your Honor. Ms. Bredehoff, note my objection. But I understand your ruling. The court, I'll note your objection. I'll overrule your objection. Thank you. I appreciate it. Any more? Ms. Vasquez, yes, I'm sorry. The court said, okay, last one. So they are going through whether or not these articles headlines will be read out to the jury. They're still going through those at sidebar. Hold on. Are you going to go the rest of today, Ms. Vasquez? No, I'm not going to take the rest of today. The court, I assume you'll have these questions and then we'll break. Is that okay? That's fine. You're going to go into the afternoon and then maybe after the first break, we'll be on redirect. Sounds good, Ms. Vasquez. Thank you. The court, back to court. The fight back and forth is that what headlines are allowed to come in. This is over damages and reputational harm. Of course, Team Depp in this is arguing she wrecked herself the same way Team Heard argued he wrecked himself, and that other things were playing into her reputation, not the Waldman statements. We're now on page 60. Recess taken for lunch. This is back from lunch. All right, Ms. Vasquez. So I plan to ask Ms. Heard about the arbitration. So Ms. Heard, the court said arbitration. Ms. Vasquez was served with an arbitration demand, and the court said arbitration for what? Ms. Vasquez, defamation. The court said the arbitration for this case. Ms. Vasquez said, yeah. Ms. Bredoff said, no, it was a breach of contract. Ms. Vasquez, no, it was defamation. The court, it was defamation. Ms. Vasquez, a demand for arbitration for defamation in California in October 2018. We've argued that. The court says, okay. Ms. Vasquez says, I'll give that to you. The court says, okay. Ms. Vasquez, we've argued that Ms. Heard opened the door when she talked yesterday in response to Ms. Bredoff's questions about how statements, Mr. Waldman's statements have been traumatizing to her. And she said, I just want him to leave me alone. I wanted to move on with my life and he won't let me. By making cases like this, he won't let me. I have to be here today. I have to be reliving it every day. The court said, right. Ms. Vasquez said, so we are arguing that she opened the door, that she was the one who fired the initial shot when she attempted to move arbitration against Mr. Depp 2 months before the op-ed was even published. So it was October of 2018. The op-ed was published in December. The court said, okay, give me more background on this for arbitration. What was this arbitration about? Ms. Vasquez, oh, I didn't know this. It was interesting when it came up in the cross-examination, because when Amber Heard kept saying, I just want to move on, but I've been dragged here. It's like, well, yeah, she's been sued. She has no choice but to be here. And then when it comes back around on cross-examination, it's like, you actually tried to force all of this to arbitration first. You indicated you were going to sue first. Well, who sues first gets the choice of venue. So I can understand Depp's team being like, well, if you're threatening to sue me, fuck it, we're suing you. That's shots fired. So I get it. I was really surprised when this came up in cross-examination during the trial, because I had no idea. This was interesting to me. So I love seeing them argue about it behind this. So let's see. The court, okay, give me more background for this arbitration. What was this arbitration about? Ms. Vasquez, Ms. Heard's arbitration actually filed by Ms. Heard in California, the court before the op-ed, Vasquez before the op-ed. It also goes towards the statements that she can't, Mr. Depp suing her. So that distorts credibility. Oh, can't, this is indiscernible. I'm wondering if it's pay the, she said she couldn't fulfill the pledged donations because of the suit. The court, okay, and she filed for arbitration for it. Ms. Vasquez filed arbitration for defamation. The court said defamation from what? Ms. Vasquez said from Mr. Depp denying in an article, a GQ article, that he ever hit her. So she sent an arbitration demand over a GQ article over statements made by Mr. Depp, not statements made by Waldman. The court said, okay. Ms. Bredoff said, this is a subject of a motion in limine. Your Honor granted a motion in limine and said none of the arbitration can come in. The arbitration was filed to go back to the divorce, and it was a breach of contract, a violation of the court said, right. So it was a divorce, all right? Ms. Bredoff said the divorce decree. The court said, okay. Ms. Bredoff said the arbiter ended up finding he did not have jurisdiction, and that was the end of it. There was no finding. There was no nothing. The court said, okay, but you just want to get into that she filed the arbitration. Ms. Vasquez says, right. The fact that she fired the first shot, not what happened at arbitration. Ms. Bredoff says, I don't think she said anything about arbitration. Oh my God. Elaine, that's not what she said. Open the door. Ms. Bredoff said, I don't think she said anything about the arbitration. I was just saying that he violated the terms of the domestic relations order. He didn't deny a public filing. It was very, very private. The court said, Oh, okay. All right. I remember this now. Okay. Sorry. Yeah. In dealing with the divorce, the arbitration, she's saying that he violated the terms of the agreement. Ms. Bredehoff said, by this Gentleman's Quarterly article. It's like, I love that she just lists out GQ by Gentleman's Quarterly instead of saying GQ. That is sending me. Okay, Elaine. Okay, Elaine. By this Gentleman's Quarterly article that he wrote, Ms. Vasquez, it wasn't violating the divorce agreement. It was an actual demand arbitration for defamation. The cause of action was defamation. I have the exhibits. So the fact that she filed it before the op-ed came out is highly relevant. And she opened the door with her testimony that Mr. Depp won't leave her alone, and she filed a counterclaim after the fact. So I think it's relevant, Your Honor. She opened the door. She said that these counterclaim statements continue to make things difficult for her, and she can't stop reliving it. But in fact, she's the one who fired the first shot. She just wanted to be left alone. Well, then why did she demand arbitration? I guess the flip side to that argument is she demanded arbitration so this wouldn't be a public lawsuit so she could be left alone. I mean, that would be the other side. I don't know. The court said, okay, but that's Bredehoff's argument to make. Ms. Bredehoff said, I don't know how that opens the door at all, Your Honor. This was an arbitration filing that the arbiter found there was no jurisdiction, so he dismissed it, and she didn't do anything further. The court said, I know, but she filed it. What she's saying is because she testified, I wanted to be left alone. I didn't want to have anything to do with it, but then she filed this. So I'll allow limited questioning. Ms. Vasquez, very limited, Your Honor. The court, what was the questions you were going to ask? Ms. Vasquez said, I wanted to repeat her testimony from yesterday, in which she says that she wants to be left alone. I'm going to ask her, you commenced a legal proceeding against Mr. Depp for defamation in October of 2018, and that was blank allegations. And then the court said, commenced an arbitration, right? Ms. Bredehoff, yeah, I think she can't say legal proceeding because arbitration is very different. I mean, the court said, is different. I agree. Commenced an arbitration. I mean, an arbitration is a legal proceeding, but okay. Ms. Vasquez, I understand. I'm happy to do it that way. And then, so I want her to look at the demand for arbitration. I'm not planning on publishing it. The court said, I think you get the first question, and that's all I'm going to do. Ms. Vasquez said, this is the demand for arbitration filed against Mr. Depp in California, correct? Ms. Bredehoff said, I don't know how that would be relevant. The court said, no, I think she opened the door with the first question about you did file it. Ms. Vasquez said, my question is that Amber Heard plaintiff versus Johnny C. Depp. I just want to show the caption. Ms. Bredehoff said, why would she need to do that? Ms. Bredehoff said, in the signature block signed by her attorney, she testified that. The court said, I'll give you the first question, and I think that's fair since and the date of when it happened. Ms. Vasquez said, okay. And can you confirm it was October 2018? The court said, okay. Ms. Vasquez, and that's 2 months before the op-ed. The court said, that's fine. Ms. Vasquez said, and 6 months before Mr. Depp filed his defamation case. The court said, that's fine. Very limited. Ms. Bredehoff, nothing beyond that. The court, okay. Ms. Vasquez, okay. Okay. All of it, okay. Okay. The court said, go ahead. Yeah, sorry. All right, thank you. You can be seated. Tom, may I please have the exhibit? Let's see. And then they go into that where she's going to ask it at some point about those. There's another sidebar. What sidebar is this? Is this the next one? Let's see. Adam Wallman, Depp's lawyer, said afterward Amber Heard and a friend in the media used fake sexual violence allegations as both a sword and a shield. Depending on their need, they have selected some of her sexual violence hoax facts as a sword, inflicting them on the public and Mr. Depp. Do you see that? Yes, I do. So this is reading through the Waldman statements. Mr. Depp, something by calling the cops, but the first attempt didn't do the trick. He told the dailymail.com. The officers came to the penthouse and thoroughly searched and interviewed and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed up the place, got their story straight under the direction of a lawyer and a publicist, and placed a second call to 911. But even this didn't have Ms. Vasquez said, I apologize. And Ms. Bredehoff said, Your Honor, may we approach? Ms. Bredehoff, she's reading beyond his statements. Ms. Vasquez said, I stopped myself. The court said she stopped herself. Ms. Bredehoff said, okay. Because she placed a second call to 911 is where it stops. She kept reading, but even this didn't have, and then said, apologize, and stopped. Ms. Vasquez said, actually, Your Honor, while we're up here, I tried to work this out with Ms. Bredehoff. Unsurprising to you. Oh my God. Unsurprising to you, we were unable to come to an agreement. I'm going to be moving to admit these articles in their entirety. Okay. And the reason is, Your Honor, it's that just like the op-ed, it came in the entirety through Ms. Heard, though Ms. Heard is only alleging 3 of the statements. The court said, correct. The court said for defamation, you have to look at the context. Ms. Vasquez said, correct. So to evaluate the defamatory meaning, so on that basis, I'm going to move to admit it. Ms. Bredehoff said, I'm going to object, Your Honor. There's a lot of hearsay in both of these documents. It's different than the op-ed. The op-ed is Amber Heard writing the op-ed. She's right about that. The op-ed is Amber Heard writing the op-ed, and then to be questioned on it, there's also the issue of a matter of public concern and intent. The rest of this article is not Adam Waldman's and it's not Johnny Depp. It's other people saying things, and it's hearsay, and it's highly prejudicial to Ms. Heard. The court said, okay, I understand Elaine's argument there completely. Like, it's an op-ed's written by the party opponent here. We get that, but the GQ article, totally different. The court said, okay. And Ms. Vasquez said, well, I disagree. And Ms. Bredehoff said, and it doesn't have anything to do with the context of what he said. The court said this might be a partial. Ms. Vasquez said, a partial. The court, maybe it could be connected to. Ms. Vasquez said, I think if I may just be heard on this. The court said, all right. Ms. Vasquez said, this is really important to Mr. Depp. Obviously, the alleged defamatory meaning of Mr. Waldman's statements have to be read in context. And I should point out to you, Your Honor, that Ms. Heard, not Ms. Bredehoff, but previously Ms. Heard, was represented by other attorneys in this matter, and they're commenting in this article. And so Mr. Waldman's statements are really responsive, we argue, right? I'm not sure Ms. Bredehoff will agree or disagree. We argue that these statements are opinions first and foremost, and second of all, that they are response or self-defense of Mr. Depp in this case. Self-defense is not a defense. Self-defense is not a defense to defamation. Truth is, self-defense is not. So, I think that it's important that these articles come in their entirety. Of course, we know that didn't happen. Again, to be perfectly frank, these aren't great articles for Mr. Depp. I don't plan to publish them to the jury. I just want to submit them into evidence. If they're in evidence, the jury can see them. So Ms. Bredehoff says, if I may be heard on that further, Mr. Waldman doesn't know what else is in the article when he made the statements. That's a fair argument. That's somebody else choosing where to put different things. You don't really know, because you could have reporters saying to him, well, this person said this. What do you think? This person said that. What do you think? You can have a reporter asking for a response. So I don't know. It's a fair argument. Though I can see the other side of it. That's a good argument to make in the moment for Elaine. He has admitted, and we will be putting the testimony in, that he made those statements, but he wasn't the author of this article. So the content is not relevant to what their meaning was on it. Instead, it would have a lot of hearsay from other people that he had no control over. He had control over what he said and he was not saying, and what he was not saying. And there's no way they could prove that he had knowledge of what the rest of the article is going to say, and therefore have context. That's a really good argument, Elaine. I think it's highly prejudicial and very much hearsay. The court said, all right, so how could the context of the article change the extent of 714? The exhibit. I think she's referring to the exhibit, not the rule of evidence. Ms. Vasquez said defamatory statements have to be read in the context of the other text within the article. The court said, if it's all attributed to Mr. Waldman, and that's fair on the court saying, but not all of this is attributed to Waldman. Ms. Vasquez said, no, I don't think that's true. And the court said, I think so, because somebody else can't place his statements there, and it become defamatory because they're placed within the article. Ms. Vasquez says, I think they have to be read in context, Your Honor. The court said, I'm going to sustain the objection. That should have been briefed. That probably shouldn't have been a sidebar argument. That probably should have been a briefed argument. Elaine made a very good argument. Waldman can't say they're responsive to other things when he didn't know. But it again shows that Elaine can be very savvy in the moment and on her feet when she chooses to. So it's interesting. The sidebars are so interesting because we get these little glimpses of the attorneys in different ways. We get more snark from Benchu. We get even more snark from Camille Vasquez. We get more clapback from the judge. It's really interesting to see the face that is presented at sidebar and the face that is presented to the jury. And it doesn't surprise me that those are different things sometimes. All right. So this is back to Waldman stuff. We are on sidebar 13, page 63. Let's go to 14, page 69. Let's see. They're talking about a recording. I'm just going back up to see what they're talking about. They're going back to the recording. Camille says, okay, so you've had plenty of time to think about how to respond to this recording, haven't you? Answer from Amber, I don't know what you mean by that. Camille, well, let's take a look at how you responded the first time. Ms. Vasquez, can we please pull up exhibit? Your Honor, this is another new. The court, do you want to come to the bench? just stop. The court, is this her deposition? Ms. Vasquez, correct. In the divorce proceeding. The court, you've got to give us a reference point. Ms. Vasquez, I apologize. The court said, so we know. Ms. Vasquez said, Ms. Heard was being deposed and we played this recording. Ms. Bredehoff, that's improper. Where you impeach, you need to ask the question, and then if her answer is different from her deposition, then she can play the question and answer. Oh shit, we're doing it again. We're doing it again. The court said, this is cross-examination. Ms. Bredehoff said, well, I understand it's still cross-examination, but there's still a proper way to impeach and an improper. They're not impeaching her. They're crossing her. There's still an improper, and there's still a proper and improper way to impeach. You can't just play the deposition excerpt and say, so. Okay, Elaine. The court, she did ask the question. She said, let's see how you did the first time. So I assume it's a different answer to the question, but I don't have a copy of that. I would just like to know what we are referencing or where we are referencing in the deposition. Ms. Vasquez, absolutely. Ms. Bredehoff, the deposition. If we could get the line and page number. The court, the line and page number before we start. Ms. Vasquez, I will do that. Let me do that. Which is fair. Ms. Bredehoff, and then we can see that. And Ms. Vasquez said, thank you. Oh, the amount of shit that Camille is navigating in this cross-examination is wild. Because not only does she have to focus on and handle the witness, which is contentious, and the witness is difficult to pin down on answers. Johnny Depp was the same way when he answered things. I thought there were times he was very difficult to pin down on answers. So Camille is having to go back through very precisely and narrow down what Amber is responding to in cross-examination, but then also has to navigate all of the wildness going on in the bench with Elaine. This is why this part of trial is so exhausting, because you've got so much going on in your brain. It's wild. But providing the pinpoint of where you're going next when you're bringing in visual elements is fair. So Ms. Vasquez says, I'm going to read it into the record and then I'll hand it off to you. Ms. Bredehoff said, I would like a copy. Ms. Vasquez said, I will. So, Your Honor, for reference, and I will provide a copy of the deposition. Ms. Heard's deposition in the divorce, I mean, they already have it, is page 372. Like Elaine at Code doesn't have Amber's divorce deposition. Come on. It's so much. It's page 372. starting at line 5 through 377, line 12. The court, all right, I think. Ms. Bredehoff said, okay, I need to have a copy. Ms. Vasquez, may I approach, Your Honor? The court, yes, ma'am. Thank you. Your Honor, with permission, may we please play? I think just play the video, not like play in court. The court, can we just get that page to make sure everybody's at? Could you say the page number again, please? Ms. Vasquez, absolutely. Ms. Bredehoff, may I have the page? Ms. Bredehoff, page 372, line 5. 377, line 1 is what I have. Ms. Vasquez said 12, line 12. The court, all right, 372. Ms. Bredehoff, if we could just have a moment, Your Honor, to read it before it's played. The court, okay. Ms. Bredehoff, I still don't think it's impeachment, Your Honor. The court, I'll overrule the objection. Go ahead. Thank you, Your Honor. If we could please just have it published to the jury and the gallery. The court, all right. Whereupon the following audio is played, female speaker. The next thing that I'm going to play to you is, would you listen to this, please? Ms. Heard, punching. This is punching. Mr. Depp, I'm sure you are. Anyway, I go to the bathroom door. When you knock on it, you just kept going. You kept going. You kept going. I tried to close the door 3 times. Ms. Bredehoff, Your Honor, may we stop that for a moment? May we approach? She should have let it finish, but she's not going to do that. So now we're at the next sidebar. The court, yes. Ms. Bredehoff, I object to them playing it. They've got the transcript on there. That's not appropriate. If they want to play the video deposition, that's one thing. But Ms. Vasquez said, all right, I'll talk to them about it. The court said, yeah. Ms. Bredehoff, they can do it through reading the deposition, Your Honor. They don't need to do that. I asked them to take it off the screen. So Ms. Bredehoff is saying that the transcript is on the screen with the video, and she's asking them to take the transcript off the screen with the video. Mrs. Vasquez said, Your Honor, we're just going to put something over it. The court said, okay, that's fine. Ms. Bredehoff, I have no objection. Ms. Vasquez, can we please start it over? Whereupon the following audio was heard. Question, the next thing I'm going to play you is you. Would you listen to this? Ms. Heard, this is punched. This is punching. Mr. Depp, I opened the bathroom door. And so now the jury gets to hear it again. I think this might have backfired for Elaine because now the jury is hearing it again. Mr. Depp, I opened the bathroom door. When you were knocking on it, you just kept going. You just kept going, kept going. I tried to close the door 3 times, just action, then wait. And then I swear when I was trying to close the door, I guess I scratched your toes. I didn't mean to do that. I bent down and I didn't say close the door and more open. Ms. Heard, I did not, but I did not mean to do that. Mr. Depp, I was bent down behind the door. Ms. Heard, I did not do anything. I did not kick at the door or slam the door into you. I did not, I swear. It was not my intention. So this is when she said he opened the door into her, I think, and hurt her foot or her toe. Okay, so you told him in that expert that you hit him with the door, but you did not intend to hit him, correct? Did you say that? I said whatever I said in that recording. Okay. When I said that, I mean, it's hard for me to remember everything. Okay. We're now on page 72. Let's see. When did they ask for sidebar? Your exact words were, I just want him to leave me alone. I just want to move on with my life and he won't let me. Do you remember that? Yes, that is correct. But that's not true, is it, Ms. Heard? It is very true. You just haven't been able to move on with your life, have you, from Mr. Depp? Well, I'm here, aren't I? Yeah. In fact, on October 11th, 2018, you actually commenced an arbitration action against Mr. Depp for defamation, didn't you? I don't recall that, no. Ms. Vasquez, Your Honor, may I approach? May we approach the court? Yes. Okay. So this is getting back into the questioning that they had talked about at sidebar earlier, and then it's now just getting worked into the cross-examination. At sidebar, Ms. Vasquez, now that she said that she doesn't recall, I think I have to show it to her to refresh her recollection. I'm not going to publish it to the jury. Ms. Bredehoff, I would have to say, Your Honor, in the deposition, she didn't have any recollection of this either. The court, she's entitled to see if it refreshes her recollection. That's it. You just have to show it to her and say, does this refresh your recollection? Okay, Ms. Vasquez said, thank you. The court said, Ms. Heard, if you could please take a look at this exhibit. And that's when they go back through that. Oh, we got another sidebar right there. Okay, hold on. Does that refresh your recollection, Ms. Heard, that you did, in fact, in October of 2018, 2 months before you published the op-ed, in this case, that's the subject of this case, you initiated an arbitration against Mr. Depp for defamation. Objection compound. No objection to that. It's not my understanding I initiated an arbitration. It's my understanding that our lawyers sent a letter. Our lawyers sent a letter to his lawyers after he called me a liar again, effectively, in an interview. And that's 2 months before your op-ed was published. That's correct. And that's 6 months before Mr. Depp filed a case against you. That's correct. So you fired the first shot, not Mr. Depp. I disagree. We sent a letter. Okay, thank you. Ms. Heard, isn't it true that you once filled out a custom form falsely so that you could, Ms. Bretterhoff, objection, may we approach? Okay, this is going to Australia. Your Honor, this is a subject of a motion in limine. Ms. Vasquez said that you denied. Ms. Bretterhoff, Your Honor said that if they were going to raise it, they had to approach. The court said, all right, let's take a look. Is it Ms. Vasquez, this is the customs form. She pleaded guilty. She was charged with falsifying a document in Australia. Your Honor ruled that this was allowed. The court, all right, which one was it? Do you remember, Ms. Bretterhoff? Your Honor, may I grab go ahead. And so now they're arguing over the lying on the customs form about the dogs. Ms. Vasquez, Ms. Heard pleaded guilty to falsifying a document in Australia. The court, all right, so that would be number 2. Correct. Ms. Bretterhoff, it was not a charge of perjury. The court said, okay. Ms. Bretterhoff said, and it was not a crime involving moral turpitude, and the court specifically found that she did not intentionally mislead in the document. The court said, okay, so what's the basis of bringing it up? So now Elaine is arguing, look, these aren't things you can impeach her on. So she's saying you can't bring this up with Australia. And Ms. Vasquez said that she pleaded guilty to falsifying a document and essentially committing perjury, which is a crime of moral turpitude. It's highly relevant to her testimony. The court said she wasn't convicted. Ms. Vasquez said she pleaded guilty, though. She was charged and pleaded guilty. She didn't have to be convicted because she pled guilty. The court said, yeah, for crimes of moral turpitude, it has to be a conviction. Ms. Bretterhoff said, and there was not. And the court said, but the basis for you getting into it is just to show a crime of moral turpitude, correct? Ms. Vasquez says, correct. And the court said, if it wasn't a conviction, so it doesn't come in for that. Ms. Bretterhoff said, while we're up here, are you planning on any of the other ones so we can cover them before? The court said, you'll approach before you. And Ms. Vasquez says, yeah, well, we've already approached about the topic, Your Honor. That took care of that one. Ms. Bretterhoff said, so are we doing anything with the immigration? And Ms. Vasquez said, no. And the court said, all right. Ms. Vasquez said, thank you. And then they moved on from that topic entirely because there was a guilty plea. There wasn't a conviction of a crime of moral turpitude, so they didn't get into it. All right. This is now getting into the sea of paparazzi at the courthouse. The sidebar, I don't see this. The court said this is a text message sent to Jerry Judge. Ms. Vasquez says, she goes on, and at the very end of her answer, you see that she testifies she alerted TMZ about the divorce. TMZ was alerted at the very end of her answer. The court said, okay. Ms. Bretterhoff said, I'm sorry, where is it? The court said, right there. Ms. Bretterhoff, I'm not finding TMZ. Ms. Vasquez, it's at the very end of her answer. I'm sorry, I don't have my copy here. I don't have it with me, Ms. Bretterhoff, to cite. I read the site. Ms. Bretterhoff, I'm not seeing TMZ. The court, it says there, some of the blank TMZ, which was alerted. Ms. Bretterhoff, it doesn't say she alerted them. In fact, she testified that Laura Wasser alerted them. The court, it is subject to direct other redirect. Her theory is that she stated it. Ms. Bretterhoff said, well, I don't think it's impeachment, Your Honor. And the court said, yes. And Ms. Bretterhoff said, it's just going to be the video deposition again. And Ms. Vasquez said, yes, thank you. And then they play the video. I remember this vividly because I was very, very confused that by the time we got through cross-examination, Amber Heard admitted it seemed that she tipped off TMZ. Miss Vasquez, if we could please play it. Miss Heard, you sent a text message to Jerry Judge on May 24th, 2016, telling Jerry Judge, I'm desperately trying to reach Johnny. It's extremely important. Please tell him. Answer, I remember sending a text message that is right in front of me right now to Jerry. And I remember sending it because I wanted to tell Johnny or have him told by Jerry or someone who knew him or was close to him. Basically, I didn't want him to find out online that I had or was about to file or I had already filed for divorce. I wanted him to know verbally. So I was trying to reach him through a third party to tell him. When I say reach, I'm specifically saying I would like him to know information coming from me or coming from Jerry from me so that he finds out about the divorce filing or my intention to do so from some other source other than TMZ, which was alerted. This was probably my favorite part of cross-examination because I had no idea. Also, here's my thoughts on this. This is the TMZ slip up. Laura Wasser was Johnny Depp's divorce attorney. But why would Amber Heard be trying to call Johnny saying you need to know before it was on TMZ if his divorce attorney knew? If his divorce attorney knew, she wouldn't be desperately trying to assert it. This was crazy to me. I was flabbergasted, but that's what I appreciated about going into this trial without having watched some of this stuff online. This was online before that, but you know, that I didn't know it. So I was like, what? I was shocked. And then the question, you slipped up there, didn't you, Miss Heard? You let it slip out that TMZ had been alerted to your filing of domestic violence restraining order, didn't you? I disagree. That's not what I'm talking about. TMZ is the same outlet that you released the video of Mr. Depp attacking the kitchen cabinet the same day before this deposition was taken, wasn't it? I didn't do that. I don't know how I could do that. TMZ owns the copyright to that video now, doesn't it? I have no idea what TMZ owns. Yeah, because they were trying to fucking copy claim it all over YouTube during the trial. Were you paid for that? I never got paid for it because I had nothing to do with it. And when Spicy Draco testified, when Morgan Tremaine testified, it seemed very much like Amber was the only one who would have been able to do it because she was the one who recorded the video. And he said it took them minutes only to verify the veracity of the video, which is why then we get to TMZ and then it was so wild. So chat, this was wild. All of this was wild. All of this was wild. So TMZ, which was alerted. Exactly. Natasha, hello. Good to see you. Hazel said the magistrate in Oz said she couldn't have a conviction on her record because it would harm her ability to travel overseas, which was necessary for her career, and she was remorseful. So that was her plea deal. Thank you for clarifying, Hazel. I appreciate it so much. This was one of the wildest parts of cross-examination. This was crazy to me because her lawyers knew this was coming. I have no idea what TMZ owns. Were you paid for that? I never got paid because I had nothing to do with it. So TMZ was lucky in getting the inside scoop from your divorce to Mr. Depp, huh? I have no idea. It's that's not my area of expertise. I wouldn't even know how to do that. And also, what does that get me? If I wanted to leak things about Johnny, I could have done that in a much more successful way, in a bigger way for years. What bigger way than leaking it to TMZ? Not when you were extorting him for $7 million. I got a fraction of what I was entitled to in the state of California, by the way. What extortion? Spicy. Tasha Van Ray is your ex-wife, right? That's right. She's my ex-partner. She's the one that you told the story that Mr. Depp was jealous of, right? And then that goes into another line of questioning. I think there's more that she could have questioned on, but also at some point, like, you've got to move on. Oh gosh, here's another sidebar. Okay, what is where are we? Let's see. You testified he tried to burn one of your favorite paintings that she did, right? I don't know if it was one of my favorites. the point of the question. You committed domestic violence against Miss Van Ray in your relationship, didn't you? No, I did not. You assaulted her at a Seattle airport, didn't you? No, I did not. And people saw that. That's not true. And it was covered in the press. Isn't that true? It was planted in the press by Johnny's team 2 days after I got the TRO. Not quite. Ms. Vasquez, can you please pull up the exhibit? Your Honor, may we approach? Ms. Bredehoff, Your Honor did not permit her to go into that. This is regarding the DV with her previous partner. The court, we said you could get into those, the articles themselves. Ms. Vasquez, the only article I plan to show is this one. It doesn't have the word in here. The court doesn't have the word is not going into evidence. Ms. Vasquez, not going into evidence. Ms. Bredehoff, not going to be shown to the jury. The court, not going to be shown to the jury. Ms. Bredehoff, okay, thank you. This is an article from 2 years ago, correct, Ms. Heard? I don't know when it was. May of 2020? That's not when it came out, no. This story started getting planted in after I got the TRO, after I got the restraining order against Johnny. The headline says Amber Heard allegedly struck. So Amber's trying to move this way. And Camille's like, what? I'm just staying the course. Amber's going to answer however Amber's going to answer. And Camille's like, we're just staying the course and asking the questions. And at this point, Camille's like, it doesn't even matter what Amber says. She's just going to stay the course in her cross-examination and not get sidetracked down, chasing down these rabbit holes. It's just not as needed. It's like, the headline says Amber Heard allegedly struck. Ms. Bredehoff, objection, Your Honor. Objection, Your Honor. Your Honor ruled she can't say that. I forgot about that. The court, if you want to approach again, sidebar. It was just the title, the court said. Ms. Vasquez, just the title. The court, the title, can't have the rest. Ms. Vasquez, right, doesn't have the word. The court, okay. The title reads, Amber Heard allegedly struck ex-girlfriend at the airport, doesn't it? Yes, and that's not true. Ms. Vasquez, may we approach? Okay. Sidebar. Your Honor, I think she's opened the door to the arrest. I mean, the fact that she's saying that that's not true, that she grabbed and assaulted her ex-girlfriend, yet she was arrested for the exact thing, I think at a minimum, it should be allowed to show her the arrest record. Again, I'm not going to be admitting it to see if that refreshes her recollection. And in fact, she did assault and grab her girlfriend. The court, she did say no. I think this opens the door too. I agree with that. Ms. Bredehoff, no, Your Honor. I'm sorry. What did Your Honor say? Oh boy, Ms. Bredehoff, right, because she's still going to deny, and that's the whole point. The arrest is not a conviction. She's the court, I'm not going to allow that. Ms. Vasquez, thank you. Ms. Bredehoff, you're going to? The court said, no, I'm not. And that's why they brought in the witness instead of the fact of the arrest. Ms. Bredehoff said, okay, thanks. I couldn't hear you. The court said, I just don't know if I was, sustaining your objection or overruling her. I wasn't sure exactly which way we were. Ms. Bredehoff said, thank you. Thank you. Ms. Vasquez, so the article title is Amber Heard allegedly struck her ex-girlfriend. Ms. Bredehoff, objection, Your Honor. She's already, the court overruled. And so they're going through that. Amber said that's another example of the smear campaign. And then her question was, so Mr. Depp is not the only domestic partner you've assaulted, is he? Amber, I never assaulted Mr. Depp or anyone that I've been romantically linked to ever. And that is the end of cross-examination, which is why they're like sprinting to the end of cross-examination. And then immediately Elaine gets up and starts going back through the questioning about Tasha Van Ray and then goes into the TMZ stuff. What I said that we would get to now that cross-examination is done, even though we have gone long, is closing arguments, sidebars. We have to do those, and we have to do the TMZ sidebars. Do y'all think we can do it? I think we can get it done. We talked way too much about Bitboy Crypto, and that's my fault. I don't know if we need to do the rebuttal. I think we have to do Morgan Tremaine's next, because the rebuttal is going to be more of the same. The sidebars are going to be exactly more of the same, with them fighting over what's been produced in the UK trial. So let's do something new. And let's go to the TMZ stuff and then go to closing. Are we good? Chat? Good. Some of you want to do redirect. If we get to redirect, we won't get to all the other stuff. And the redirect, it's just the same stuff over and over and over and over. You guys are like, no, do some of the redirect. Okay, let's go through. There are 4 more sidebars. Okay. On this day, there are 4 more sidebars on this day. And then we are going to the TMZ stuff and then closing. All right. Deal. Okay, deal. Let's see. Let's see. That was in July 2016. It was the first mediation attempt. We met after that, and Johnny very much looked me in the eye. Please tell the jury about the next meeting after he said, "You will not see my eyes again." Is this when she was mocking him? When she was like, "You will never see my eyes again." Do you remember that? I was so appalled that Elaine was doing that when she was mocking his testimony. We met in the lawyer's office. They gave us a moment. Johnny kissed me again, held me. I cried. He cried. And then we had a short exchange. And he put a note in my pocket that said, "I love you, dead or alive, my Slim," with his new phone number on it. Let's see. I would like to bring up, Michelle, if you can, defendant's exhibit. Do you recognize this? Objection, Your Honor. May we approach? Yes, ma'am. Sidebar. Ms. Vasquez, so we are now in redirect. Correct. She's clarifying because this is no longer cross-examination. So we are now in redirect. Ms. Vasquez, this is something that was never produced. And if it was produced part of a late production and past discovery cutoff. Ms. Bredehoff, so it was produced by Mr. Depp. It was used in the UK trial. Mr. Depp produced it as a black and white in this case. This came out in color. It's true, though, through Mr. Young's view, but it's not responsive to any document requests that they've asked for. The court, I'm going to sustain the objection. So whatever they were trying to bring in was a, oh no. Can you tell the jury what the coaster was that he slipped into your pocket, what it said? It said, "I'll love you forever, my Slim, dead or alive." And what, if anything, did it have in addition his new phone number? So just to be clear, it was so confusing to me that she was going on and on about whether or not he was looking her in the eye. She thought it was, I don't know if the jury even cared at this point, but she thought it was important to say that that's not true and that she wanted Amber to have the opportunity to give this answer because he's guilty. He knows he's lying. Otherwise, why can't he look at me? I survived that man, and I'm here and I'm able to look at him. Where are we next? Let's see. You were asked a number of times by Ms. Vasquez if you took pictures from your incidents earlier in your relationship. Yes. Why didn't you? It was something I started doing only kind of incidentally. You know, I was commenting to my best friend. I was looking for support from my mom, things like that. You know, there was, I'm ashamed to say, never a thought that this would happen. I mean, not until December and my best friend taking pictures of me to capture it did that even, that wasn't even a thing. It's been suggested by Ms. Vasquez to you in your questions that you didn't tell anyone about the abuse until the TRO. Is that true? Ms. Vasquez, objection, Your Honor, leading. Ms. Bredehoff, all right. The court sustained. Ms. Bredehoff, all right. Who did you tell about the abuse during the time it was happening? Ms. Vasquez, objection, Your Honor, leading. Ms. Bredehoff, not offered. Ms. Vasquez, hearsay. The court sustained. Ms. Bredehoff, Your Honor, it's prior consistent statement. The court, but it's leading and it's sustained. Next question, Ms. Bredehoff. Okay. What, if anything, did you tell to anyone about the abuse? Objection, Your Honor, hearsay. The court all sustained the objection. Ms. Bredehoff, Your Honor, may I approach, Your Honor? The court, that's fine. Sidebar. The court, you don't have forever to do that. I mean, there has to be a timeline you're trying to talk about. Ms. Bredehoff, actually, Your Honor, oh, the chat is saying hello to Morgan Tremaine, which means I'm guessing Morgan Tremaine is in the chat. So hello, Morgan. Don't worry. We're getting to your testimony next. Hello. We're getting there. The chat vetoed me moving on, so we're finishing these last two sidebars. So then we're going, I didn't mean to summon you by saying TMZ 6 times, but I'm glad that you're in the chat. Hello. The chat was simping. Be careful. Chat, be hospitable. No excessive simping, please. Be, you guys, act like we're prepared. All right. The court, that's fine. Sidebar. You don't have forever to do that. I mean, there has to be a timeline you're talking about. You can't just be like, when and always, right? Actually, Your Honor, there's two different ways I think it comes in on prior consistent statements. If she wasn't impeached, they're not prior consistent statements. Your Honor, I submitted a brief earlier to the court, Your Honor. The court, I've seen it, Ms. Bredehoff. So there are two parts to this. One part is just the prior consistent statements on specifics. And I will have some of that. But the second is the offer to rebuff allegations of recent fabrication before litigation arose. Oh, she's reading something. She's definitely reading down the line. But the second is offer to rebuff allegations of recent fabrication before litigation arose. Well, that's not recent. This litigation arose a fucking million years ago. And the Virginia Supreme Court has further defined this principle, and I'm citing Faison here, where a witness has been assailed on the ground that the story is a recent fabrication or that they have had some motive to testify falsely. Proof that they gave a similar account of the transaction when the motive did not exist before the effect of such an account can be foreseen or motives of interest would have been induced. A different statement is admissible, and that's the case. In this instance, they're clearly suggesting that she's made this up for the TRO and that it was never there before. She didn't tell anybody. It didn't exist. And I think that brings in, Ms. Vasquez says, that's not what we're saying. Ms. Bredehoff said, all of the statements, Your Honor. The court also sustained the objection. Ms. Bredehoff, Your Honor, just so I make a complete record on that, I'm removing the admission of the exhibit, and I tried to put in the last Wednesday and Thursday that were for hearsay because they're prior consistent statements. That doesn't get you. Okay. That's not how that means. That's not how that means. I just want to put on the record, Your Honor, the court said, okay, that's fine, but it's not prior consistent statements, so I'll sustain the objection. And then they go through it. Again, this is going to get another sidebar. How many times overruled? Roughly about 10. Can you name them? Yes, Ms. Vasquez. Objection, Your Honor. Hearsay. I think she can. It's not offered. It's just to show that she informed people before. There are suggestions. Ms. Vasquez. Objection, Your Honor. Can we approach? This is, again, at this point, I remember this very well. All of this. Forrest Faye said the chat is starstruck. I'm not surprised. Which I get. Of course. It's fine. Let's see. Your Honor, she's making arguments in front of the jury. The court, I understand. Ms. Vasquez, and it's just inappropriate. It is. Oh, Morgan, you did not disrupt. You are all good. The chat's allowed to be starstruck. We're 3 hours into sidebars at this point. Welcome distraction. We didn't mean to summon you. I'm sure you were busy, but hi. So the court, I understand, Ms. Vasquez, and it's just inappropriate. I mean, you said at the outset of the trial, speaking objections are not to be permitted, just one word objections, legal objections. The court said, okay, so, and Ms. Bredehoff said, so, Your Honor, I think it's been suggested that she made these up. I think she should be at least, the court said, right. She said 10 people. So why do we need the names of the people? Ms. Bredehoff said, okay. The court said, I'll sustain the objection. Thank you. Back to open court. All right. Oh my God. I forgot how much they started fighting in the sidebars. I forgot how much they started fight. Oh God, they're back to back. I forgot how much they started fighting. You were asked a number of times by Ms. Vasquez if you looked at pictures from your incidents early in the relationship. It's been suggested by Ms. Vasquez to you in your questions that you didn't tell anyone about the abuse until the TRO. Is that true? Objection, Your Honor. Leading. Ms. Bredehoff, all right. But it's leading. Sustained. Oh, we already just did this one. Okay. Where is... Okay, back to open court. How many people did you tell? Roughly about 10. Why does this keep jumping back to this spot? All right, one more. There are too many sidebars. I have a significant amount of scar tissue in my nose, Ms. Vasquez. Objection, Your Honor. The court also sustained the objection. What, if any, difficulty you have breathing? Objection, leading. Ms. Bredehoff, what, if anything? And that does cure it, Your Honor. The court, it doesn't, but I'll overrule the objection. Ms. Bredehoff, thank you. Do you remember the question? I have a significant amount of trouble breathing at night, and I've been putting off having surgery for it. Do you recall? Objection, Your Honor. Leading, Ms. Bredehoff, Your Honor, I'm entitled to go into with what Ms. Vasquez asked. The court objection is to leading. I'll sustain the objection. Oh, Ms. Bredehoff, okay. Did you report? What, if anything, did you report? Objection, leading, and hearsay. The court approach. The court is just like, come on. The court approach. Sidebar. The court, you can't just put what, if any. You can't just put what, if any. Ms. Bredehoff, I can't hear you. I think at this point, Ms. Bredehoff's like, I don't want to hear you. The court, you can't put what, if any, in front of a whole statement and say you're directing her directly to that. There are ways to ask the question. You just can't ask it in those ways. Ms. Bredehoff, so if I'm going to, Your Honor, I would like to do a preview. The court said, sure. Ms. Bredehoff, there is notes from Aaron Filati's records that were excluded from 1216. Yeah, excluded. The court, okay. Ms. Vasquez read from 1217. The court said, okay. Ms. Bredehoff said, I'm going to now bring in 1216, prior consistent statement, because she was impeached with 1217 from the hotel about injuries. In fact, Aaron Filati documented the day before that client states JD was inebriated, client states disagreement escalated, and states husband abuse to head, client denies loss of consciousness, headache, and closed eye. I would encourage client to notify Dr. Kipper and then go to emergency room. Client declines, states friend Rocky is here and that husband will not be able to enter home. This is a direct response to, this is a prior consistent statement. Your Honor, Ms. Vasquez asked her about 1217, which is in evidence. The court said, right. Ms. Bredehoff said, and suggested that she didn't tell her about it, that she went and got, that Dr. Kipper wrote and suggested that she didn't tell him about the incident. So she's suggesting she falsified the incident. This is a prior consistent statement to Nurse Filati. So I'm going to, Ms. Vasquez said, Your Honor, it's hearsay. The court said, well, she's saying she's not using it. She says, exception to hearsay, it's prior consistent statement. Ms. Bredehoff said, correct. Ms. Vasquez said, but it's still double hearsay, Your Honor, because it's not misheard statement. It's misheard statement allegedly to a nurse, and it's recorded on a document. That's double hearsay. That's still double hearsay. The nurse isn't testifying to that. Ms. Bredehoff said, that's the whole point of having an exception to hearsay. Ms. Vasquez, no, you still can't get over. The court said, I understand. I see what you're saying. Ms. Vasquez said, and you need an exception. Ms. Bredehoff said, and there's a medical records exception. Ms. Vasquez, no, there isn't. Okay, different. There is there are exceptions with regard to records, but this is not that circumstance. Jesus Christ, this is wild. No, there isn't. The court, who is CT? Ms. Bredehoff, client. The court, client. Okay. Ms. Vasquez, by the way, my question wasn't, what injuries did you tell Aaron Filati about? Which would have elicited that testimony, perhaps. But you still have to get over the 2 levels of hearsay. She doesn't have an exception for the 2 levels of hearsay, or the 2 layers of hearsay. Ms. Bredehoff said, I don't agree. A prior inconsistent statement is an exception to the hearsay rule, and so is the medical record. The court said, but medical record, you still have to get over the hearsay in the medical record. Ms. Vasquez, you have to get over the hearsay. Shh, Camille, at this point, shh. Ms. Bredehoff, it's not hearsay. The court, anyways, where we're at Ms. Vasquez, correct. She's trying to offer it. Ms. Bredehoff said it's specifically intended to impeach her and suggest that she did not tell Aaron Filati about the injury, and she brought up the 1217 note, which is in evidence. Ms. Vasquez, I did not. The court, all right, this is what I'm going to do. I'm not going to allow this into evidence because it's double hearsay, but because I'm not going to allow this into evidence because it is double hearsay, but because it is a prior consistent statement. If you want to ask her, did you tell on 1216, did you tell the nurse about your injuries? I'm going to allow it because that would be a prior consistent statement, but I'm not going to allow the notes in. Does that make sense, Ms. Bredehoff? It's just, I know the jury doesn't get to see that, and they see the 1217 and they're misled. The court said, but you have a hearsay issue inside of that. I'm not allowing you to ask the question for prior inconsistent statement because I think that's appropriate. Ms. Vasquez said, just what? And not reading in. The court said, and not reading in the note, just an open-ended question. What did you ask her? Ms. Bredehoff said, then I also have the text message exchanges between Aaron and Amber Heard on 1216 about this. Defendant's Exhibit 535. Oh, my mouse just stopped working. That's not helpful. Your Honor, and for the record, I want to move in plaintiff's 46A to add in the 1216-15. Which part are you saying is a prior consistent statement? Bredehoff, she's telling her about the headache and goes through, and then she finds her, I think the third page, Your Honor, is the exception. Show me the prior consistent statement. Ms. Vasquez, Your Honor, I'm going to just object. None of this should be admitted. The court, well, the prior consistent statement, Ms. Vasquez said prior, the court said, go ahead. Prior consistent statements cannot be admitted into evidence because they're used to rehabilitate the witness. The court said, right. And Ms. Vasquez said, but it cannot be admitted into evidence. The court said, right. So you can ask her the question, but I'm not going to allow the documents. Ms. Vasquez said they have to be open-ended and they can't be quoting. It's hearsay. The court said you can't quote the text. And this is the problem, is that Elaine wouldn't not quote the text, and that's where this back and forth went far afield. So now they're talking about what questions they're going to ask. Did you tell Nurse Filati on 1216 about injuries you sustained from the 1215 attack? I did. I believe I sent her pictures. And what did you text her? Yes, she guided me through a concussion check. Do you recall Dr. Laurel Anderson testifying that she saw two black eyes on 1217? Objection, Your Honor, leading. Sustained. Okay, what, if anything, do you recall from Laurel Anderson's testimony? Objection, Your Honor, this is outside the scope of cross. Ms. Bredehoff, it's a prior consistent statement. The court, I'm going to sustain. Ms. Bredehoff, the observations from 1217, the court sustained the objection. Next question, may I approach? Sidebar. We are now on sidebar, I think, 26. Ms. Vasquez, the court said prior consistent statements can't be testimony that's in evidence. That's not how it works. Oh, y'all, these are so long. I want to move on. Ms. Bredehoff, they brought in Dr. Kipper's notes from 1217 alleging that she didn't say anything about it. And 1217, she's appearing in front of Dr. Anderson. The court, again, prior consistent statements can be permitted when you're asking about testimony that's not her consistent statement. Ms. Bredehoff, Ms. Vasquez got to talk about it.
Your Honor, Miss Vasquez got to talk about it. Why can't I talk about it? She got to do it. Nuh-uh, Your Honor, it's not fair. She got to do it.
The court, that's not prior consistent statements, though. I'm going to sustain the objection. You can move on. You can feel the life draining from the judge. You could just feel it. When in December did you see Dr. Laurel Anderson? Objection, lack of foundation. The court overruled. I saw her 2 days after the attack. So on what day did you see her? Are we done? That was 26. Where's sidebar 27? Ms. Vasquez, objection, Your Honor, hearsay. The court also sustained the objection. Next question. You were asked some questions about Officer Melissa Sainz' testimony. What, if anything, do you recall relating to Officer Melissa Sainz' testimony relating to your injuries? Jesus Christ, what is that question? Objection, Your Honor, hearsay. Ms. Bredehoff, Your Honor said I could redirect after cross-examination when the court, do you want to approach? The court, you can redirect, but not hearsay. I mean, you can hear the court being like, rules apply. Ms. Vasquez, hearsay and leading. Ms. Bredehoff, Your Honor, it's patently not fair.
It's patently not fair for them to cross-examine and then Your Honor to say, that's for redirect. And I say, she answers these questions and she's answering what Melissa's saying. She's testifying to what this is Ms. Vasquez testifying to what these people testifying to and asking them questions. I object to that because I think that's not the proper way to do it. Your Honor says, that's for redirect. And now I'm trying to redirect. The court.
You still can't redirect on hearsay. You still can't redirect with hearsay. It's like, yes, you can redirect, but the rules of evidence still apply. The court, you still can't redirect with hearsay, Ms. Vasquez, or leading. Camille's like, we're not done yet. Or leading. You can't lead either. The court said, or leading. I'm not sure from that question exactly. I mean, are you trying to get to whether her testimony was when she testified? Because that's what she was talking about, was the testimony, the in-court statement she made for a deposition that was played as a witness. Is that what you're trying to get to, Ms. Bredehoff? Yes. The court, that's not what you asked. Ms. Bredehoff, okay, all right, but it's not hearsay if it's an in-court statement, so I can ask that because the court said, you're talking about her testimony if she knows what her testimony was. Ms. Vasquez, but you still can't lead the witness. Elaine didn't understand that this wasn't hearsay when she was objecting to this being hearsay. And now Elaine's like, but it's not hearsay because it's an in-court statement. Yeah, you fought about that 3 hours ago. Ms. Vasquez, but you still can't lead the witness. The court, but you still can't lead. Ms. Bredehoff, okay, thank you. Thank you. Open court. What, if anything, do you recall of Officer Science's testimony in this case relating to your injuries and the property destruction? That is the last sidebar of this transcript because this is coming to the end of this day. The fact that they got through another, I don't know, however many pages without a sidebar is amazing. But it was a lot of hearsay sustained. Okay, now we are moving on. Now we are moving on to the rebuttal witnesses and to TMZ, which is going to be Morgan Tremaine's testimony. There's also that hearing with regard to what day that was in week 6. So let me see if I can find it. I think it is Kate Moss Day. So May 25th. Let me go pull that transcript for May 25th. And then I will, don't worry, I'll swoop, chat. I will absolutely swoop once we pull up this transcript. Let's see. Where are we? Examination of Kate Moss, examination of Shannon Curry, examination of Johnny Depp, examination of Morgan Tremaine. So this starts on, it doesn't say what page number. 7331. So let me cue that up real quick. Elaine, the rules of evidence are simple and finite. It's not even a big book. Yes. Exactly. Yes. Exactly. Yes. It's not even a big book. All right. Let me zoom to get to the right page. It's going to take me a moment to zoom to get to the right page. I should just, here, let me see if I can find it. If I do this. Here we go. Here's the beginning of testimony. Hopefully it won't screw up the sidebars. You know what? I'll just go through this manually because it's not that long of testimony. All right. I don't know if Morgan is still in the chat. I mean, there's 11,000 of you here, but if Morgan, if you're still in the chat, we're going through your testimony. Hi. Ugh, my hair is between the in-ears and the glasses and the hat. It's just all of the things. I want to go back and find the TMZ argument, but we're going to go find that next. Let's see. Mr. Depp calls Morgan Tremaine. The court, I didn't quite get that. Mr. Depp calls Morgan Tremaine. All right. Let's see. Sworn in. What do you do for a living? I produce esports events and design video games. 2016, what did you do? I worked as the field assignment manager at TMZ. And then we go through the TMZ process, that testimony I think y'all remember. So you receive a link. What was the link? A video of Johnny Depp smashing cabinets. And you received this video in your inbox, correct? I did. What did you do once you received that video? We downloaded it. We alerted the web editor who was sitting next to me at the time. We downloaded it. We instructed by the news producer to do what we call slap bumpers and a bug on it, which is putting the dun 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 at the beginning and the end, and then putting a translucent watermark over it, which indicates copyright ownership. What did you do after you did that? Was it posted? It was posted. Where was it posted? TMZ.com. Did you do anything else related to Amber Heard that day? Yes, I received a tip that Amber Heard would be arriving at LAX, so I dispatched camera people to LAX. And then this goes through how they obtain copyright, what they do to obtain copyright, what was going on with the video. Did TMZ edit the video? No, not even a little. When we receive something and it's edited, there's a clear indicator, because there are all sorts of journalistic practices that uses. When there's an edit, you do what's called like a white flash transition, which covers the entire screen with white, very clearly indicate that there was an edit here for time or whatever. I don't see any sidebars. And now cross-examination. There might not be any sidebars. So did you know what the video was? So how do you know what the video was shown at this trial? I was alerted by a friend that TMZ was being kind of talked about in this trial, so I had seen a clip of that. So you watched some of this trial, correct? Okay, when did you first reach out to counsel for Mr. Depp? I believe it was 6 days ago, whatever that date would be. I would have to do the math. All right. Remember at this point, Elaine is like sprinting. Elaine is sprinting through this testimony because they are running out of time very much on this. And you received a subpoena, I think, in your care of your attorney. Then they were talking about the attorneys. Objection calls for speculation. The court sustained. Next question. I'm not a lawyer. You do know this case is being televised, right? I'm aware that there are cameras. I mean, he just said he saw a clip. So, yes, aware that there are cameras. So this gets you your 15 minutes of fame, doesn't it? Ms. Vasquez, objection, Your Honor, argumentative. Ms. Bredehoff, I can ask that question. The court overruled. So I stand to gain nothing from this. I'm actually putting myself kind of the target of TMZ, a very litigious organization. I'm not seeking any 15 minutes here, but you're welcome to speculate. I could see the same thing by taking Amber Heard as a client for you. A little argumentative, don't you think? Hardly. And then we get into the TRO. Lack of foundation. I don't think there is a single sidebar in any of this, but we will see. There might not be a single sidebar during Morgan's testimony, chat. And that's the end. That is the end of the testimony. No sidebars. I completely forgot. We got to relive the iconic moment, but hold on. We need to go find, I forgot what day it was. The day that TMZ came and argued, it would have been the day before. It was late in the day before Morgan Tremaine testified. So that would have been May 24th. Let's go see if we can find, well, let's look at the beginning of the day on this one and see if there's anything at the beginning of the day that indicates. Let's look there first, and then we'll go to the end of the day before. So let's see. I think it was the day before. I just want to see if it comes up before the witnesses. Let's see. So you're saying this witness actually saw it? Yeah, she witnessed the assault. She's the arresting officer. Ms. Bredehoff, no, she is not. Ms. Vasquez, I can represent to the court as an officer of the court that she will not testify that she arrested Ms. Heard. She's only going to testify. The court said she can't testify. She's an officer. So this is regarding the officer that testifies. She can't say anything about being an officer, just somebody at the airport that observed the incident between Amber Heard and Tasha Van Ray. All right, what else? Let's see. Thank you, Your Honor. And as an officer of the court, I will represent she will not testify. She was formerly a police officer, very limited testimony. What is Ben Chu on about? There's a lobby. I didn't know who it was. Mr. Rottenborn, this is the testimony of Amber related to Kate Moss. This is one sentence. She said, I just, in my head, instantly think of Kate Moss on the stairs when I swing at him. The court, right. Rottenborn said, so in our view, asking about Kate Moss, did Johnny ever hurt you on the stairs? That's fair game. The court said anything on the stairs. Ms. Vasquez says, it's only related to the stairs, but Your Honor, I will represent that in cross-examination, I also inquired of Ms. Heard whether or not what about Miss Moss she remembered, and she testified in cross-examination that she heard a rumor. Mr. Chu said, Mr. Rottenborn said, I don't remember that. I don't remember that part. I don't have that. I don't recall that. I'm not doubting what she's saying, but if I heard a rumor, it's the rumor about what happened on the stairs. So what I'm saying is they shouldn't be allowed to say elicit testimony about, oh, Johnny was so sweet, Johnny never hit me, if they want to get her and ask her, a couple of questions about did he hit you on the stairs. I think that's fair game, but anything beyond that is beyond the scope of rebuttal. And I fear that's what they're trying to do. And I just want to stem this off now. Mr. Chu, it's a very short examination and there is the testimony question. Ms. Vasquez, cross-examination. Mr. Chu, from Ms. Vasquez, you thought he was going to throw your sister down the stairs like he had thrown Kate Moss down the stairs, right? Quote, he swung at Whitney and I heard a rumor about that and that's what I thought of. The court said, right. Mr. Chu, she testified about it both on direct. The court, okay, yes, about the stairs. Court is done with Mr. Chu. About the stairs. About the stairs. It's a very limited inquiry about whether he ever physically harmed her. We've been doing that throughout the Ms. Vasquez. They brought in Mr. Chu. Clearly, what she's saying is that Johnny was violent with her, and she's going to say that's not true. Mr. Rottenborn said that's beyond the scope, Your Honor. The only two times Kate Moss came up is this rumor about what happened on the stairs. To get them to elicit testimony about was he ever violent, which I know is what they're going to try to do, that's beyond the scope. Mr. Rottenborn keeps his argument so succinct. So succinct. It's like, they're going to try to do this, Your Honor. Yes. And he's like, and they're not going to do that. He just a much more succinct in the sidebar. Mr. Chu said they elicited testimony from Ellen Birkin about Johnny throwing a bottle 30 years ago against a wall in a crowded room and being abusive. Mr. Rottenborn said, Your Honor has held both parties to objections that are made at the time. And if objections aren't made at the time, then we waive them. That they could have brought up these issues. The court said they objected to Ellen Birkin's deposition testimony. Ms. Vasquez said, even in a motion in limine, Your Honor, Rottenborn understood, but my understanding is not on the same basis that we're objecting now. He transitions so well. He's just like, understood, but my understanding is not the same basis that we're objecting now. I'm saying this is beyond the scope of this. It's rebuttal testimony. Your Honor has been very strict. The court, but they're saying they're rebutting Ellen Birkin also, which is a good argument for them. Ms. Bredehoff, they never raised it in interrogatories. Mr. Rottenborn, they can't call Kate Moss to rebut Ellen Birkin, Your Honor. That's inappropriate rebuttal testimony. This is the one and only instance where Kate Moss came up, which was a rumor that Johnny had injured her on stairs, which wasn't limited to Amber. And that was a widely circulated rumor. That should be the court said, I'm going to limit it to just the stairs. Ben Chu says, Your Honor, I understand. The court said, the only reason it's coming in is because she opened the door on cross-examination about the stairs. I think she did that on direct examination, but okay. Mr. Chu said, but won't the jury think they're not allowed to ask whether he ever hit her? They're going to think, the court said, well, I mean, he could have done it in the case in chief. I didn't even know if it would have come in the case in chief. But what I'm saying is the only reason it was overruled because the door was open because she mentioned Kate Moss on the stairs. She did that. And that's why it's coming in to testify that nothing happened on the stairs. Mr. Chu, may I set the context of how she knows? The court said, well, yeah, she knows is fine. How she knows him, if it's like you dated for 5 years, that's fine. Mr. Chu said, I just don't want to run afoul of the court's rule. The court said, you can do that. And then they narrow down what's happening. So we're going to look at the day before for the TMZ hearing and then closing. That's the plan. All right. The sky's all growly. It's Middle Tennessee right now, just as I'm pulling up this next transcript, because I need to go to the next day. Middle Tennessee right now is having like Satan's summer. It is my least favorite time of year. In California, it would get all like Santa Ana windy, where it was dry and hot. But here it's like so rude because it gets cold and you mentally are prepared for sweaters and it's cool at night. And then all of a sudden, bam, 85 degrees in the middle of the day. And you're like, fuck, I was ready for it to be 50. What is this? So we are living in Satan's summer. It is just the absolute worst, like fake summer number 4. I hate it. All right. We need to go to May 24th. All right. Trial day 22, May 24th. Okay. Let's see. Let's go and do this. All right. When does that happen? Let's see. Via video. I don't even see the motion in the transcript. I thought it was day 22. You guys said it's day 22 in the afternoon. I thought it was day 22. Maybe is at the end and not identified as a witness. Hold on. Let's see. Let's see. TMZ does not come up in this at all. So it can't. Maybe it's just not in the trial transcript. You guys are saying it's day 23. All right. Let me go look on day 23 then. But I just had day 23 up. Did I miss it? I might have. It might have been at, I just want to see if there was any argument before it. But let's see. The TMZ motion is set for 1 p.m. They'll be here at 1 p.m. to argue their motion. It might not be in the trial transcript because oh, nope, here it is. All right. Found it. Let's see what they say before this motion happens. And then we saw the motion happen. Where are we? That's about the metadata expert. Let's see. All right. Right. Are we ready for the other motion, Ms. Vasquez? Yes. Mr. Chu. Yes, Your Honor. The court. Okay. Got that matter. Let me take up the emergency motion for Mr. Toobin. Mr. Toobin. Yes, Your Honor. The court. How are you doing, sir? Mr. Toobin. Very well, Your Honor. Thank you. If you could just come to the center, Your Honor, before we begin, may I just approach Mr. Chu? Thank you, Your Honor. Thank you, sir. Give it to the other side. Certainly, Your Honor. I've got to make this relatively short, as you can understand, but I wanted to take up your motion. I had read your motion and the declaration and everything attached in this case, and I've reviewed it, so I'd rather not regurgitate it based on our time limit, but anything you wish to add is fine. If you could focus on you a little bit. All right, so as far as your comments about Virginia Rule of Evidence, 2:508, that's a criminal rule. So that's not, Mr. Toobin says, understood. The court said, not your strongest argument. As far as what goes on when and if the witness testifies, whether it's hearsay or it's third-party knowledge, that's something I'll deal with at trial. So again, that's not what I'm concerned with. As far as the Supreme Court Rule 314, which I would like you to talk about a little bit, as far as the intervention, I've got to tell you where I'm at right now. The issue I have with your argument is intervention obviously would make you a plaintiff or a defendant in the case, and it has to deal with an issue that's germane to this case. So this is a defamation case. So if you could just tailor your arguments. So there are no sidebars here. This we all heard in open court. Let's see. The court says if he takes a stand and he asserts some sort of privilege, then that's something I will deal with at the time. Toobin says, sure, but I'm here because the scenario where he may not assert that privilege. The court said, right, exactly. That's what I'm saying. All of your cases were the opposite, where they did assert privilege. Toobin said, right, well, it's a unique situation. The court said, right, I understand. You may have some issues with a former employee, and you have some avenues to go deal with that. Mr. Toobin says, once he testifies and the privilege is waived, we've lost our opportunity to intervene and proceed. Yeah, well, you could sue him afterwards. I don't think they should. That's what she's saying. Well, Morgan's in the chat saying, I was playing Mario Kart in the back room. They really didn't want you to testify, but there's nothing they could do to stop you from testifying. And I think Morgan's testimony was succinct and to the point. And I don't think it threw TMZ under the bus. It didn't even really get into stuff that would be proprietary. It's just like, this is our process. Alley Cat asked, can the person on the stand hear the sidebars? Generally not. Generally not. They're not supposed to be able to. We did the Doofenshmirtz sidebars. We're getting to closing next. I love Mario Kart. I'm very bad at it, but I love it. Tubin says, but the privilege it has by the Virginia Supreme Court in the Brown case and applied by the Circuit Court, it is very important underpinning of the relationship between reporters and sources. This is a bit different without the ability to enforce its promises by current employees because no source was named. It was just process. Finally, Your Honor, TMZ lacks standing. This is the argument from the other side. Let's see if there's any sidebar here. I think this was all in open court, and we watched it. So I'm going to get to the end of this and see if there's any sidebar. All right, thank you, Your Honor. Ms. Bredehoff, Your Honor, the court microphone. And then they voir dire Morgan Knight from Hicksville, but it doesn't look like much of this is at sidebar, except right here. Mr. Rottenborn, but I truly am the messenger here. Let's see. Mr. Chu, Your Honor, I don't think that's appropriate. Certainly, I don't think a proffer is necessary or appropriate in this case. The court, I'm not going to do a proffer, Ms. Bredehoff. Mr. Rottenborn, I'm sorry, so sorry. The court, Mr. Rottenborn, almost at lunch, Mr. Rottenborn. But I truly am the messenger here. The court, that's fine. I think we need Ms. Myers. Sidebar. The court, well, if somebody could just represent her here, Mr. Murphy, I'm not trying to keep Your Honor. The court, no, I know you want to know what to do for the witness. Yes, I heard Your Honor say he can to the metadata. I would like to know exactly what that means because there's hundreds and hundreds of lines of metadata. So then they're getting into a sidebar about what can be testified to after lunch, what can be cross-examined on the report and the metadata disclosures. All right, let's go to closings. Shall we, chat? Shall we? I think so. Space Cat, did anyone find the last Pokemon Go Community Day odd? Yes. It just felt random. I'm a court reporter and frequently feel like I'm playing Mario Kart in a blank room. That's very fair. Let's go to closing arguments, shall we? That's my favorite part. It's always my favorite part. It's time to go to closings. Let me pull them up. Where did I go? What happened? And then we're done. Lyndon, that's exactly right. And then we're putting a pin in it. And then the only thing we're going to be doing is after that would be insurance stuff. But this would be done. Next community day is Timber. That I'm excited about. Are any of you guys playing Pokemon Go Sleep or Pokemon Sleep? I guess it's not Pokemon Go Sleep. That's not the right way to say it, but Pokemon Sleep is so much fun. I've become a wee bit obsessed. I'm very much enjoying it in a very nerdy way. All right, let's go to closings. Then this case is done. I don't think there's anything else. I think it should be done. I really, really want it to be done. I want it to be done. And then we'll do a little bit on the Shabusiness sentencing on Thursday and see what else we have going on so we can close that case, kind of just do a little bit of that live court hearing and close it. But let's finish closing arguments. Thank you. A huge thank you to our moderators and to Miguelina, my producer, for hanging with me on this super sized final edition, because I delightfully got a little sidetracked at the beginning of stream today, but that's okay. We can stream for a while. I appreciate it. It's not as long as a trial day. So thank you to that. And I'm going to take a quick second to remind those of you that are here again, if you haven't been here the whole show, just give me 2 seconds, okay? 2 seconds. If you have not signed up for our app yet, it is time to go get our free app so you know when I am streaming. LawNerdAlert.com from your mobile device will get you to the download page where you can download our app for iOS or Android for free. It is our way to stay in touch with you. So did I say Law Nerd Alert? LawNerdApp.com. Sorry, my brain stopped. LawNerdApp.com or in the App Store. This will get you everything you need to know what I'm doing, when I'm doing, what I'm streaming, when I'm streaming on your mobile device. This will take you right to your App Store, or you can search in the App Store for Law Nerd or Law Nerd app and you will find it. So with all of that, you guys, for those of you who are just getting here, please go check out the app. We will get there. I'm going to need to build a banner for it, Miguelina, because I forgot to, so we can have it at the bottom. I could do it right now. LawNerdApp.com is going to keep you guys in the loop, especially in the fall. I'm traveling next week for a conference. Our schedule gets a little crazy. So, yes. So for those of you that are just popping into the chat now, yes, we have an app. So for those of you that are downloading it, thank you. The app has such good notifications. Thank you. That was the goal. Emily, will you do the case closed bumper? Yes, when we finish closings, I'm doing the case closed bumper. I don't know if I'll get to all of our Q&A, but I'm doing the case closed bumper when we get there. Love to be live from Scranton, Bin Replay 2, Goat and Pickle Ready. I mean, we've done both today, that's for sure. Both today. Glad to have you here live. Joined during Depp Heard watching with my infant. It's been busy then. And congratulations on your little law nerd. So good to see all of the member chats, you guys. Thank you so much. Anyone else enlightened by Becky's part on Netflix? I'm going to ask you guys later in the community tab. I'm thinking about watching what's been added on Netflix and giving my thoughts about whether or not it adds to the motion for new trial or not. That's my thought. Are you guys interested? If you're interested, let me know. For sure. For those of you that are international crew, Lynn B, I hope it's Lynn. I'm loving the app being in Denmark, or maybe just because of YouTube. This app is actually giving me all notifications. That is the goal. We knew that YouTube notifications weren't working for everybody. We knew that text app didn't work for everybody. We knew that that was an issue. I have the app, but it didn't notify me today. You should have gotten the notification today, so check your notification settings. And if you have problems with it, let us know. Tinsley, good to see you. Glad to be enjoying a live with you. Was in the doctor's office when my app went off. Told the doctor we need to make this snappy. Take care of the doctor's office, Tinsley, but it's good to see you. Thank you so much. We're going to get to a few questions and then we're going to get to closing. I pledge my eternal gratitude to any law nerd who would edit and combine original Emily's live coverage of this trial with Sidebars coverage at specific moments. That sounds like a doctoral project. Invite Morgan onto stream so he can let us know how much of the sidebars he could hear from the witness stand. He's in the chat, so hopefully he's been able to do that. Morgan, we will have to have a conversation, if you even want to, for the podcast or something. We had talked about that ages ago, and then like life happened and things got crazy. She is stating what she said on the stand in court, and that's hearsay. Elaine, probably. It's so crazy. Birdie made a comment. I have the app, but the notification came in late. Might be because of iOS 17. We have had some iOS 17 quirks, but the notification should work. Elizabeth, are you still doing YouTube? I don't understand the answer to that question. I don't understand the question. I'm sorry, Elizabeth. I don't understand the question, but yes, currently, if that helps. Do you know if the depositions of JD and AH before the trial available for viewing, the ones from January? I know some of them have been leaked on the internet, but I do not know where, and I cannot verify the veracity of where those might be found or where those links might be. I knew that they were available online. Can you imagine explaining all of this to Dr. B? Some of these things I don't try. But it's her testimony. It's hearsay. That stuff just, I text Judge Abby. I'm 37 and getting out of a Lambo is like getting out of bed when you're 8 months pregnant. Definitely going to need a hand. They're so low to the ground. Get the Lamborghini Urus SUV. I've seen a lot of Lamborghini SUVs around here and then the Maserati SUVs, but I do realize I live I live near Nashville, so it's not as if I moved from LA away from musicians and celebrities. I moved to Nashville with musicians and celebrities. How is a FOIA request made? The public can do it. It depends on the department, but yes, the public can make requests. Glad I finally caught a stream. Glad you are here. Thank you for creating this community. I love this community. It's why I do what I do, because I like chatting with y'all. Let's get to closing, y'all. Let's go. Let's go. Let's go. All right. Closing time. Why does this seem really short? Did I pull up the wrong one? Hold on. I think I want to make sure I pulled up the right one, because that one seemed very short. We need May 27th. There we go. I was like, wait a second, that is the wrong transcript. All right, friends. Are you ready? Let's close this out with some closing argument sidebars. If my phone goes off with a storm warning, it will be even better. It'll just be the perfect way to end all of it. All right. Good morning, Your Honor. Good morning. Do you have any matters? No, Your Honor. The court. That's what I like to hear. Okay, fantastic. Just let me take a minute to get my computer up, please. All right. Just also, I did, for the ones that are going to go back to the jury, I did that off the Depp and Heard on the titles, so it's just numbers on the jury instructions. Thank you, thank you, thank you. The jury entered. Ladies and gentlemen of the jury, the court is going to instruct you. All right, let's zoom past jury instructions because we watched them and there's no objections. The fact that there were objections during closing is so worried. It's so wild. Bertie said, Emily, I think you mean if an Amber Alert goes off. I know. I still don't think it was actually an Amber Alert. I think it was weather. I really do, but it was funny. LOL, you've been here in Tennessee long enough. You started saying y'all. It's actually funny because I started saying y'all in like high school, but I listened also. I love 90s country music. So I started saying y'all in high school, and I would joke that Southern California counted as Southern enough for me to say y'all. So it's kind of stuck, and it works for so many things. It's such a all-inclusive word. It's just like y'all and all y'alls. It's perfect. So it's either that or dude or dudes, you dudes. This guy is so growly. Let me see. I wonder if they're going to cancel. I'm keeping an eye on my messages just in case they cancel my kiddos' practice because it is that type of weather. Oh, it's 90. Jesus. Okay. Let me. All right. Closing arguments. Ms. Vasquez, good morning. Good morning. There we go. Let us start finding our sidebars. 12? There's 12. Fucking hell. 12 sidebars during closing? Stop it. Stop it. All right, let's see who's talking. Let's see. I can't tell who is giving this part of the closing. Mr. Depp dated major figures like Winona Ryder, Kate Moss, Vanessa Paradis. This must be Mr. Chu. Before Amber Heard, ladies and gentlemen, no woman ever before Amber Heard ever claimed that Mr. Depp raised a hand to her in his 58 years. And no other woman since Ms. Heard made that false claim has repeated it. This is a Me Too without any Me Too. To the contrary, ladies and gentlemen, you heard Kate Moss 2 days ago testify. This woman who has never testified in any proceeding ever, a very private person, testified that Mr. Depp never abused her and that Ms. Heard lied to you and that she lied to you twice when she told you, objection, Your Honor. Do you want to approach? Sure. This is going to be a misstating testimony. Mr. Rottenborn absolutely misstates the evidence. That's way beyond argument. You didn't let him ask that question of Miss Moss. This is not a bad argument because it was only about the staircase. And Ben, look, I know y'all have your feelings about Rottenborn, but Rottenborn is the best lawyer on the defense team And Rottenborn made good arguments at Sidebar about this and was on the button, was like, you wouldn't allow this to go this far. Stop it. Mr. Chu, when she said she suggested twice that the court stairs, but it was involving the stairs. Mr. Chu, correct. That's what I'm going to say. Ben Chu is like, that's where I'm going with this. What? He's like, it's not beyond argument. I'm going there. I understand why Rottenborn jumped in on this. I get it, because did Kate Moss testify that he absolutely never ever abused her? Or was it when they were talking about the stairs? I don't fault Rottenborn for objecting. I think that it is on the line. Did she testify that Miss Depp never abused her and that Miss Heard lied to you? I mean, it might be she testified Mr. Depp never abused her, that Miss Heard lied to you about the staircase. I get it. Ben Chu's like, what? I'm getting there. The court, that's what he's going to say, okay? The court's like, what? Everybody's like, what? I understand. I understand where you're coming for, Rottenborn. On this one, I understand where you're at. Mr. Chu, ladies and gentlemen, as I was saying, Miss Heard lied to you twice when she suggested to you that Mr. Depp pushed Kate Moss down the stairs. And he did get there. But I get where Rottenborn was being protective. If only Rottenborn knew how many objections were to come. These are my monkeys said, but Rottenborn didn't let him finish. He didn't. Rottenborn was doing good lawyering, had to try. I think Rottenborn is a good lawyer. There are times when, he annoyed me just like every other lawyer, but I think he is a good lawyer and he did make good arguments. And he did really try to narrow that down doing his job. So I don't fault him for that. That's not ridiculous. But Ben Chu's like, Your Honor, I'm getting there. What? I'm getting there. Ben Chu does not get flustered by much, right? He was pretty unflappable this whole trial. Let's see. All right, ladies and gentlemen, let's go ahead and take a break at this time. Again, this case has not been submitted to you yet, so this is lunch. Bredehoff, Your Honor, 2 items. Okay, sure. Bredehoff. The first of those, Your Honor, the court, wait. Bredehoff, sorry. The court, okay, what's your issue? Ms. Bredehoff. The first of these is we believe that the arguments on damages and restoring the reputation has opened up the door for the UK judgment. They're still trying. They're real salty about the UK judgment. They are still trying. So they really, 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 really want to get it done. Oh, I see Julie clarifying in the comments. A few of you were asking if I was leaving YouTube because of the app. No, the app is an alert system. Thank you, Julie, for clarifying. I appreciate it. The app is our notification system to stay in touch with you so that we can stream here. No, we're not going anywhere. Thank you, Julie. I appreciate that. So Bredehoff is trying again to get into the UK. I can see why. They're just trying. Bredehoff, the first of these is we believe the arguments on damages and restoring the reputation has opened up the door for the UK judgment. The court, no, definitely not. Evidence is done. Oh my word. No, definitely not. Evidence is done. Evidence is done. Elaine, no. The court. Ms. Bredehoff, okay, Your Honor. The second thing, I just saw while Mr. Chu was arguing, I think we made a mistake in both verdict forms. On the last, I think you'll appreciate it as well. The court, sorry, Judy. Last day, we're going to take Judy's mic out. Ms. Bredehoff, she's never going to forgive me. I believe this word should be any instead of all. I think what this does is require them to find all 3. The court said, okay, so you want us to change the last page if you answered yes to all the questions? Ms. Bredehoff said to any. The court said no to all the questions. Well, all the questions in 1, all the questions in 2, and all the questions in 3. Ms. Bredehoff said or. Mr. Rottenborn said 1, 2, 4, 3. What? The court said, you see what I'm saying? I can explain that to them if you want. Ms. Bredehoff said, I think that would be helpful. The court said at the end, I'll explain that to them. That means you have to answer all the questions. Ms. Bredehoff said, I think it works. The court said, you created the form, right? Rottenborn said, yes. The court said, so you can see that the court is now looking at Rottenborn. I can see in this transcript that the court is looking at Rottenborn. You created the form, right? And Rottenborn's like, yes. The court said, so I'm correct, right? And Rottenborn said, yes, that's right. So now Elaine is arguing, and the judge is looking at Rottenborn as the adult in the room, being like, I'm right? Can you tell your co-counsel to stop? The court is like, Rottenborn, you created the form. Why is Elaine arguing over the form? Why aren't Elaine and Rottenborn on the same page? God, to have a drink with Rottenborn under like a cone of silence. Can you imagine? I can't imagine that these attorneys get on well. Rottenborn, yes, that's right. The court, I'll explain that to them to make sure we have it right. Ms. Bredehoff, thank you, Your Honor. Why didn't you and Rottenborn just talk if he made the forms? Ms. Bredehoff said, thank you, Your Honor. The court, did you break that too? Ms. Vasquez, I don't think so. It's still on, so that's a good thing. Mr. Chu, keep laughing. It's my fault. The court, let's make it 11:10. Thank you, Your Honor. We'll come back at 11:10. All rise. So they're taking a break for the jury. That's the morning break. Let's see the next sidebar. Who's arguing? I'm guessing this is Elaine. Then what does he do? He rearranges the furniture, or he might have knocked something off, off one of the countertops or something. This is Elaine. I think this is the testimony of his bodyguards. No. In closing, it's not, I think this is the testimony. It is this is this. But you saw the pictures. He went through and trashed the place again as he left. Now, the next part of this is the police coming. I'm making my own head hurt. Io tells the police he's in New York. He calls the New York police, 911. He's afraid they're not going to get there fast enough. Well, if they're in New York and she's in LA, then yes, NYPD is probably not going to get to New York fast enough. Thank you for stopping by, Morgan. I was trying to grab it. The chat jumped. The Lawnards. Thank you for thanking the Lawnards. They are great. I'm sure everybody was excited to see your answers about what was happening. Thank you for stopping by. But yes, I'm sure Io was like, hey, they're never going to get to LA in time. Yep, they're in New York. So he's afraid they're not going to get there fast enough. He still remembers December 15th because he came in afterwards and saw all of the injuries on Amber and all of the evidence. And he's testified that Amber's still in there and the police haven't come and that Johnny's going to kill her. He calls a friend in LA and says, please call 911. We've got to get somebody there fast. She calls 911. So we have 2 calls. You'll see the call summary. And the call summary shows 2 calls really close in proximity here. So it's not them, we didn't get the first police officer, so we'll rough up the place and make the second one. You'll see that they're like 8 minutes apart up there, but it took 2 hours to dispatch 2 different ones. And Amber and everyone had any idea the second one. Ones are coming. The first ones come in, we've talked about it. We've shown you the pictures. The police officers admitted that those pictures could very much have been what was there that night. I think they said that's what they saw, but okay. Officer Haddon, it was his first week on the job. Officer Sines was 3 years on the job at that point. They say, they tell Josh that if she will press charges, if she'll give a name, we can file a report, make an arrest. She wouldn't do that. You hear from Detective Sandana. That's the domestic violence. Objection, may we approach? Mr. Chu, she blatantly misstated the testimony of the police officer. The police officer said there was no sign of injury. There was no arrest. She needs to correct that. Ms. Bredehoff, Josh Drew testified. The police officers told him she's got a mark on her face. There's property damage, The court, was that in evidence? Ms. Bredehoff, yes, that was. Ben Chu, no, it's not, Your Honor. Ms. Bredehoff said, no, it did make it in evidence. Mr. Chu, the police officer said there was no sign of injury. The court, well, I know the police officer. She just said Mr. Drew. Ms. Bredehoff, no. Josh Drew's came in. It came in. Mr. Chu, I don't believe that's correct, Your Honor. The court, I know what the police officer said. Ms. Bredehoff said it came in through Josh Drew. The court, well, I'll allow it. Go ahead. Mr. Chu will correct that. So there's an argument between the witness testimony, but that's what happens in a trial. So she doubles down. You recall Josh Drew saying that the officer told him, if she'll give a name, we'll make an arrest. He definitely said that. He definitely said that. He definitely said that, but in any event, she would not cooperate. She didn't want to. And then they go on to talk about the other officers. Let's go to the next sidebar. I don't remember Josh Drew's testimony off the top of my head, and we haven't read any of it here because it was a deposition and there were no sidebars during the deposition because they were all cut together with agreement. So clearly that's 100% false. Clearly they knew it. Clearly there's malice in making that statement. They're trying to suggest that she's manufacturing evidence with her friends to try to frame Mr. Depp. Nothing could be further from the truth on that one. And she didn't want those police officers to press charges. Now let's go to the third one. Oh, let's talk about the makeup for just a moment while we're going to the third one. The makeup thing. The fresh face. Natural. Those were Adam Waldman planting these when he talked to the ECB people. Remember the testimony here? So did you talk to Mr. Waldman? Did you talk to Mr. Waldman? Mr. Waldman was trying to plant in all of these people's minds. Oh, shit. Mr. Chu, objection, Your Honor. Ms. Bredehoff, that something wasn't, if you could approach sidebar. Mr. Chu, she's completely misstating testimony here. Ms. Bredehoff, I don't agree. Mr. Chu, she just is. Ms. Bredehoff, I don't agree. Mr. Chu, none of them said that they were planted by Adam Waldman. They all said this is a truthful statement. She's just lying. Holy shit. Ben Chu's like, she's lying. Your Honor, she's lying. Ben Chu's pissed. She's just lying. Ms. Bredehoff, I'm not lying, Your Honor. Mr. Chu, she is lying. The court, well, Ms. Bredehoff, no. We asked specifically about Adam Waldman. Your Honor will recall that. And they said, I don't remember. Yes, I did talk to him. The court, right. But nobody said he planted those statements, these statements. Ms. Bredehoff, no, I didn't. And I didn't say that he planted it. The court, you just said that. Oh boy. The court, right. But nobody said he planted those statements. Ms. Bredehoff, no, I didn't. And I didn't say that he planted it. The court, you just said that. Ms. Bredehoff said, I accused him of planting it. Oh, the parsing the words. Honk banana, no. Ben Chu, Your Honor, may the record reflect her pants are very clearly on fire. Hangry says she uses lies and closing statements synonymously. This is very, very, very snarky. Very snarky. They're pissed. Of course they're pissed. It matters. You just said that. I accused him of planting it. You can't just make stuff up in closing. The court, if you could clear that up, Ms. Bredehoff, okay, thanks. The court, Ms. Bredehoff. So I didn't say that any of the witnesses admitted that Adam Waldman planted that. I'm saying he planted it. That's me arguing the planted. And that's because it's all the same thing. Yeah, she does use them synonymously. She wasn't wearing any makeup. She was natural. She wasn't wearing a stitch of makeup. Every one of them said the exact same thing. But why did you say that? She's an actor. She's not going to go outside her house, without putting makeup on. In a lot of those photos, look, I'm not going to argue about makeup. There is a difference between a full glam and a very natural look. Very natural looking makeup generally doesn't have the coverage that she is arguing. Whatever. All of the witnesses are like, no, she looks very natural. She's beautiful. She looks natural. Okay. Why on earth would she not put makeup on so she would cover those up? Why on earth would she not want to cover up those bruises? It makes no sense. But you know what? Guys saw her here. You guys, sorry. You saw Amber on the stand. There were days where she didn't wear eye makeup. And a lot of people think that she's not wearing makeup when she doesn't have mascara and eyeliner on. She has different looks. And some of them were with eye makeup and some of them without. And people misunderstand, especially people that aren't good in makeup. A lot of men, frankly, go, oh, then she probably doesn't have makeup. And that's where the mistake happens. But you heard her testimony and you heard her makeup artist testimony that she doesn't go out of her home without concealer. Like literally the lightest concealer, a very natural looking concealer, not a full ass, anyway, concealer. All right. Next sidebar. Well, they argue over concealer. Let's see. Dr. Hughes and Dr. Spiegel testified about Bonnie Jacobs' notes. And I remember I was holding that. You don't get to see them. Ladies and gentlemen of the jury, you don't get to see them, but I was holding them in my hand. Trust me. Trust me. Trust me. You don't get to see them, but they testified that they went through them. Dr. Hughes testified that she also spoke to Bonnie Jacobs. She kept contemporaneous notes from 2011 when she first started seeing Amber, and the abuses documented in those notes is what Dr. Hughes testified they started in 2012, both physical and sexual abuse. Mr. Chu, objection, Your Honor. Ms. Bredehoff, Dr. Hughes testified to that.
Your Honor, I don't know why he's objecting. I don't know why he's objecting. She, totally testified to that. So, what?
This is a lawyer that's already been called a liar at the bench where the court is like, you need to fix that statement. The audacity. Mr. Chu, may court approach? The court's like, sidebar. The court, yes, sir. Mr. Chu, she keeps misstating. She continues to lie to the jury. Ms. Bredehoff, no, I'm not.
I know you are, but what am I? I'm not a liar. You are.
No, I'm not. I'm definitely not misstating that one. I'm definitely not misstating that one. You got me last time, Your Honor. I wasn't trying to imply. You got me last time, but I know I'm not misstating on this one. Gosh. Yeah, motion. Yeah, yep. No, I'm not. I'm definitely not misstating that one. Mr. Chu, she's continuing to lie and misstate the evidence. The court, which lie do you say there? That was not in the testimony. Ms. Bredehoff, oh, it was. It absolutely was. Mr. Chu, it was not. Well, what do you believe was the testimony? Ms. Bredehoff, Dr. Hughes testified that Bonnie Jacobs' notes documented both physical and sexual abuse. She also said that she talked to her and confirmed. That was the first day of her testimony. The court, I just don't have the transcript, so I'm not sure. Mr. Chu, that's not accurate, Your Honor. She continues to do this. Ms. Bredehoff, he can argue whatever he wants, but that's absolutely what she said. Mr. Chu, she can't lie to the jury like that. Ms. Bredehoff, and then I asked Dr. Curry about them after. The court, what was in the notes? Whatever. I know she reviewed the notes, but what was in the notes? Did that come into evidence? No, because it's hearsay. Mr. Chu, no, it did not. Because it was all hearsay. Because it was all hearsay. Hearsay. Ms. Bredehoff, yes, well, the court, I'm not sure the notes. Bredehoff, characterization of it, not the actual notes did not. The court, characterization? Bredehoff, characterization. Dr. Hughes said those things were in her notes. The court, her characterization of them. Ms. Bredehoff, characterization of them, right. That's not actually in her notes. Nama asked a great question that I bet a lot of you are wondering. Why doesn't she have the transcript? The transcripts they're not doing daily transcripts, or at least the court does not have daily transcripts. So the court can't just flip to what the testimony was. The court has to rely on their own recollection. The court generally doesn't have replay. So the court's going off of their memory of the testimony, and the court often takes notes during testimony. Ms. Bredehoff, characterization of them, right. The court's leading her into a trap at this point. Danger, danger, Elaine, danger. The court, that's not actually in her notes. Mr. Chu, correct. Ms. Bredehoff, no. She said that Mr. Chu, she needs to correct that. She continues to lie to the jury. Ms. Bredehoff, she says that the notes reflected physical and sexual abuse. She said that. That was her testimony. She did. Mr. Chu, that is not evidence, Your Honor. The court, I don't recall that. Ms. Bredehoff, she absolutely did. I mean, she absolutely did. The court, you can use she characterized it as such. I don't know that you can say they were actually in there. Mr. Chu, yeah, she's misstated that to the jury. Ms. Bredehoff, no, I have not misstated it. Mr. Chu, yes, you did. Ms. Bredehoff, I have not submitted my testimony at all. That's very important evidence from us because we could get those notes and we tried several times. No, you couldn't. Mr. Chu, she's saying it's in evidence when it's not. The court, well, but she did characterize the evidence. You can characterize the notes. Ms. Bredehoff, thank you, Your Honor. Ms. Bredehoff, so Dr. Hughes specifically characterized Dr. Bonnie Jacobs' notes as reflecting both physical and sexual abuse. Dr. Spiegel confirmed that later and said the same. And when I asked Dr. Curry if she had reviewed those notes, she said yes, but she had not comment, Mr. Chu, Your Honor, objection, Ms. Bredehoff, and she did not acknowledge that it was in there. All right, sidebar. Wackadoodle Spiegel did not say that. I think when we get to wackadoodle, when we get to calling one of the experts a wackadoodle at sidebar, maybe we've gotten too comfortable with the court. But I'm not mad about it. I think if you're a judge, you're like, Mr. Chu, a little too snarky guy, rein it back. But at this point, I imagine Ben Chu is pissed because he believes Elaine has misstated stuff to the jury. So he's mad. Mr. Chu, wackadoodle Spiegel did not say that. The court, Dr. Spiegel didn't say that. Mr. Chu, could she please correct that? Ms. Bredehoff, yes, he did. Ben Chu, no, he didn't. The court, I know you are, but what am I? Just kidding. The court, he said he reviewed her notes, but he didn't say anything. He didn't characterize her. Ms. Bredehoff said, I just said he confirmed. The court, but he didn't confirm. He said, I reviewed the notes and said nothing about that. Mr. Chu, would you please ask her to retract that? The court, I will. Ms. Bredehoff, Dr. Spiegel confirmed that he reviewed Bonnie Jacobs' notes as well. And when I asked Dr. Curry, she said she had reviewed them, but she had no comment. But she didn't deny that those were in there. Amber Heard testified that she went back, and because of Bonnie Jacobs' notes, she realized for the first time that the abuse started much earlier than she even realized before. Oh, the wackadoodle Spiegel. Ben's so done. It's a little informal. Not all judges would take it, but I think that Judge A is done. They call her a gold digger, right? But she obviously couldn't have done it for the money because, first of all, remember the testimony of Laura Wasser, the divorce attorney? She said that California is a no-fault state and community property, so Amber doesn't have to have abuse. She could have just divorced him for irreconcilable differences, for abandonment, for adultery, for anything. She doesn't need an excuse, and she gets 50% of whatever he earns during the time of the marriage unless they had a prenup or a postnup. The testimony from Michelle Mulrooney was that Amber completely cooperated with the prenup and postnup. Now we have this plaintiff's exhibit. It says how much he made in 2015. It was $43 million. Remember, Mr. Spindler, Depp's expert, who said that he made $22 million in 2016. So you've got $65 million. Amber was entitled to 31.5 at least. That doesn't include all take back ends. Oh, it doesn't include all the back ends from Pirates 5. She was entitled to that money. So she didn't need to say anything. She could have said, I don't like you anymore. I don't like the color of your hair. I'm going to divorce you. Mr. Chu, Your Honor, we're going to object. Sidebar. Mr. Chu, she's making legal conclusions. It's quite clear that Judge White had ruled very early in this case, we're not litigating the divorce here. She's telling the jury her legal opinions of California divorce law. Ms. Bredehoff, this is what Laura Wasser testified to. Mr. Chu, no, it's not. Yes, it is. No, it's not. Yes, it is. No, it's not. Your Honor, she's lying to the jury. The court, you can make arguments if they're in evidence. Ms. Bredehoff, they are. Mr. Chu, no, they're not. Ms. Bredehoff, Laura Wasser, yes, they are. Laura Wasser and Michelle Maroney, I'm sorry, Your Honor, but this is going against our time because we're already tough on time. Mr. Chu, you're already out of time. Ms. Bredehoff, I mean, he's already done this 3 times, okay? The court, we won't count the sidebars. Ms. Bredehoff, thank you. Mr. Chu, Your Honor, it's not in evidence. Ms. Bredehoff, it is. Mr. Chu, you wouldn't let it into evidence. Ms. Bredehoff, oh, I absolutely got that in. She's like, I won. I absolutely got that in. Mr. Chu, we did the whole deposition designations. It was ruled very early in this case. We're not relitigating the divorce case, Ms. Bredehoff. I'm 100% certain that, Mr. Chu, and she's wrong on the lawsuit too. Ms. Bredehoff, it's in Laura Wasser's and it's in Michelle Maroney's. Laura Wasser has both the no fault and the community property in there. Michelle Maroney has the community property in there. The court, I know I heard about community property. Mr. Chu, she's saying she's entitled to 31.25. I mean, it's ridiculous. Ms. Bredehoff, right? And we put the tax returns in and Spindler testified to the amounts. So you do the math. It's 31. The court, so, but yeah, you do the math. Ms. Bredehoff, right. Mr. Chu, she's making, Ms. Bredehoff, but we even asked in cross-examination to one of them, the 31.5. I mean, I'm entitled, Mr. Chu. She's telling the jury, Ms. Bredehoff, to make these arguments, oh, now they're just arguing over each other, of falsity about the application of California law. Ms. Bredehoff, no. Mr. Chu, that doesn't take into account the, Ms. Bredehoff, it was elicited to debts that are assumed by Mr. Depp. No, Wasser, Judge White said very early on, we're not relitigating the divorce. Ms. Bredehoff, no, you don't take debt into account. The court, we're at the end of talking about the divorce. Ms. Bredehoff, I'm near the end. Yes. The court's like, me too. No, the court said, okay, all right. Ms. Bredehoff, I'm doing the motivation here. Oh, the motivation for the divorce. Okay. It took me a minute. Like, what motivation are you doing? Are you trying to like gear yourself up for the rest of closing? I'm like, what is happening? All right, Ms. Bredehoff. Okay. I'm going to move on, but I'm entitled to that. The court, I understand, but if you're going to do calculations, you're going to let them know this is mere inference of the evidence that's in. That's fine. Then we'll go from there. Okay? Ben Chu, thank you, Your Honor. Back to open court. So if you do the math, Amber's entitled to at least 7 or 31.5. What did she take? 7? What did she do with the 7? She gives it to charity. What now, Elaine? What now? What now? She gives it to charity, or she intends to give it to charity. Mm-hmm. Now, they make much ado about the pledge versus donate, but both the corporate designees for the ACLU and the Children's Hospital said donation and pledge are interchangeable. These are pledges. They use them synonymously. Oh, there's some more. The court. So let's come back at 2:10. Mr. Chu, thank you, Your Honor. The court, and just for the record, plaintiffs have 39 minutes left for rebuttal. Defendants have 6. I remember this moment in court. Ben Chu, thank you, Your Honor. Ms. Bredehoff, Your Honor, can we get any of those back from the sidebars? The court, I didn't take any time from the sidebars. 0 off the sidebars. It's all from testimony. Next sidebar. The court, all right, it's out of my hands. I have a few notes, okay? So the jury leaves the courtroom. Please make sure Jamie knows where you want to be contacted for any jury questions. When there is a verdict, I'll give you at least an hour lead time. It will always be at the top of the hour. So for example, if we get a verdict at 10:20 in the morning, it wouldn't be read until noon. So it's always going to be at the top of the hour, at least 60 minutes later, if that makes sense. That gives you time. I would ask at least one attorney is close enough within a 10-minute range for any questions. I'd appreciate that, okay? And I know some of the attorneys are going to be leaving. I just wanted to thank you all for your for your professionalism and your hard work during this case. It's much easier being a judge when you have excellent trial attorneys in front of you. It does make it easier when they know the rules of evidence and hearsay. I'm sorry, that's not what the court said. That's not what the court said. It does make it easier. And I just want to thank the attorneys and litigants for the kindness and the great demeanor you've shown to my staff and the courthouse staff and the deputies and the sheriffs. I really appreciate it. It means a great deal to me, okay? I also appreciate Judy because she's a rock star. Yes. Standing ovation. The court. Well, that's a first. Okay. Ms. Bredehoff, your staff and your deputies have been absolutely phenomenal all the way through, just outstanding with everything. We really appreciate them, and we appreciate your honor as well. The court. All right. There is one thing on which Ms. Bredehoff and we respectfully disagree. Completely agree. The court. Okay. I'm glad on the last day, we finally have agreement. Was he trying to be funny or did he misspeak? Mr. Chu, thank you, Your Honor. We're very grateful. Thank you. Ms. Bredehoff, one matter if we can't approach the court. You want to approach? Sure. Just for old time's sake. Ms. Bredehoff, I might have misheard it, but I thought at the end of your explanation, Your Honor's explanation of the verdict form, I thought Your Honor said if they find, the court said no. No on any of the court said any of the pages. If you put a no on any page, you don't get to damages. Ms. Bredehoff, as long as Your Honor, it just was still confusing to me, but the important thing is Your Honor's on it. The court, we're on it. We're good. Mr. Chu, thank you very much. Ms. Bredehoff, really thank you. Yes, really thank you. We do really thank you. The court, all right. If we hear anything, we'll let you know. Okay, all right. Thank you. Thank you. All rise. Done. The court, since it's a long weekend, let's bring them in and send them home, okay? Whereupon the jury entered, and the following took place, and they excused the jury for the weekend. And that is the end. It's the end. Y'all, we've done the sidebars, or at least a good portion of the sidebars, not every single sidebar, but a good portion of the sidebars. We are done with the sidebars. Chat, we have been streaming for 4 hours and 15 minutes because we had to talk about Bitboy Crypto getting arrested because I got distracted and then the ADHD would not let me let it go. I was like, I need to know. So we definitely added some time onto our stream today. But I think we're there. Mike, I said this. This is a great comment. Mike said, I dislike Rottenborn, but he could have won this case. When they did opening statements, I said, if they try the case that Rottenborn laid out in opening statements, Johnny Depp loses, Amber Heard wins. They did not follow Rottenborn's lead. I think Rottenborn had the stronger play, but Rottenborn and Elaine, it seemed, were butting heads. You have to have a unified team. You have to. You have to have a unified team. So y'all, thank you for the trip to Virginia with me today. We're going to take a look at just a few of the questions, and then I have got to go. I'm tired, I'm hungry, and I have to make sure that the podcast is ready for you tomorrow. And I am not done with what I need to do to make that happen yet. So, Johnny Depp and Amber Heard. There are a few things going on in the insurance lawsuit, but it's not this case. So, I think we're done. I'm calling it. Chat, we're calling it. Case closed. Done. Done. We have departed Virginia for now, and we are done with this case. Let me look at a few more of our comments, and then we are going to wrap. So I can finish the things that I have to finish because I have to finish them. Kimberly said, motion to review the legal accusations in Oz Media's new video. I don't know what that is. I had a hard time understanding, so it would be nice to have your take on what was alleged. I know nothing about this, so I will loosely say I will take a look. I love that you're just making your own thing with the app. That's what we've decided to do. When we don't have a solution that works for us, we're just doing it ourselves. Watching you while I should be working. We can do both, John. We can do both. You're more fun. Well, thank you. Just put me on in the background. Monuments of speculation. Love your perspective on these cases. Huge respect. Thank you so much. I hope to just bring it all to the forefront and have a chat about what the law is and sometimes what the rules are and what they say. Wishing Gamar. Oh, I do not pronounce well, but yes, happy young Gamar. Gamar Shatamiya Tova. To all who observed, I hope I said that right, Ali. I apologize for anything I butchered. I downloaded yesterday the app. Thank you. You're welcome. The app is working great. Thank you. Lots of love for the app. Thank you for all the member chats, members. I appreciate it. Thank you, Emily. Is there a BTS today? Lori, I do them on Monday because I normally record on Monday. Thank you, Warren, for fixing me early on in the stream. Sean, 9 days in the hospital and happy I have this community to look forward to. Thank you. Hang in there and heal quickly, Sean. I am so sorry. Ippy Fluffy says, we appreciated not being bombarded with junk. I try to make that a bit easier in our communities where we have control of it. So, Angela said, my teenage son thinks of the Roman Empire all the time. Mm-hmm. Yep. Today, when my kiddo went to school, my kiddo has a color guard rifle, which is a giant wooden rifle. And today somebody was like, does that kid have a rifle? And I was just like, it's a giant wooden, oh gosh. So like, it's just too funny. Sorry. Speaking of teenage kids, today my kid was like, why are people confused? It's like a giant white fake wooden rifle for color guard. Oh, teenagers. Anyway, it is band season. So band is on my mind quite a lot because it's color guard season. I guess not everybody goes to the halftime shows, maybe, or doesn't realize that that's actually what they're spinning and throwing up in the air a lot. It's too funny. All right, law nerds, it is time to wrap. I am tired. It is hot. The sky is grumbly. We're going to go do all the things. Needs to put in a violin case. Dan, I don't think that will help. I don't think that will help at all. I mean, they don't look anything like the color guard rifles. Sorry, it popped into my brain. Let's see. Do we do anything with the old alert system? Will we get double notifications? All of the text crew is winding down, so there won't be anything there. So I will still put things up in Instagram for a little bit and we'll go from there. So let's see. So hopefully that answers that question. Crystal Blue Persuasion. It's my birthday. Can I get a shout out? Happy birthday. We got 4 hours of sidebars. My son looked at me like I completely lost it when I asked about the Roman Empire. That's too funny. I love it. No grown-up should be confused. They just look like color guard, right? I guess if people don't know what color guard is, I don't know. We live in weird times. Late. No. I love that Morgan came in to say hello to us. I thought it was fantastic. I used to be able to quads on a rifle and guard. That's amazing. My kid has a solo 6 right now, but it is pushing a 7, which is why he's wild, but it's a lot of fun. It's that season. It's band season. Emily, it's football season. It's not. It's band season for me. Chat, I'm going to go eat. Thank you. I appreciate you, and I will see you soon. You guys are the best. Law nerds, you make it so fun to do what I've got, what I get to do for a living, to get to talk about all of the cases that I love. It's so much fun. So thank you. I'm so here for the marching band nerd talk. That's where my brain is today, right? I love it. So it's football time in Tennessee. It better not be this hot this weekend. I am sweating in my office. I actually need to go make sure the AC is on. But with all of that, you guys, I appreciate you. Thank you. I will talk to you soon. Law nerds, it's time. It's 4:30. Oh my God. There's work that has to be done today. I will see all of you soon. Thank you so much. Let's roll the outro and say goodbye. Case closed, all the things. Bye, guys.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.